Committee will be in order. Good morning and welcome to the Joint Legislative Committee on Government Oversight. Chair apologizes for being late. My other committee went very late last night, and I thought to myself, what am I doing with my own schedule since I'm responsible for it? Nonetheless, we are here. On this day, we have a full morning schedule. Maybe we'll go a little bit into the afternoon and maybe we won't. But before we start our agenda, we'll have committee introductions. Today, I'll start on my left, Representative Eder.
Good morning, Representative John Eder, serving District 136, Alfred, Lyman, and Waterboro.
Mike Tipping, representing Senate District 8 in Penobscot County.
Michael Lemlin, representing House District 53, Chelsea, Randolph, Pittston, and Dresden.
Good morning, I'm Representative Chad Perkins. I represent District 31, which is 7 towns in southeast Piscataquis County.
Representative Stowe.
Thank you, Mr. Chair. Good morning. My name is Holly Stover. I represent House District 48, including the 6 coastal towns of Boothbay, Boothbay Harbor, Southport, Edgecombe, Westport Island, and South Bristol.
Good morning. I'm Senator Stacey Guerin, representing the beautiful winter wonderland of Piscataquis County, Moosehead Lake, Mount Katahdin, and part of Penobscot County.
Hello, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Jeff Timberlake, 17.
Madam Chair.
Good morning. I'm Anne Marie Mastracchio. I represent House District 142, which is part of the city of Sanford and the village of Springvale.
Representative Stover.
Mr. Chair, I would ask that we just take a moment of silence this morning to remember our colleague, Jeff Evangelos, who passed yesterday. Thank you.
The chair would agree that we can take a moment of silence to honor our former colleague, Jeff Evangelos, of friendship. I'm Craig Hickman. I represent Senate District 14, which are 12 municipalities in southern Kennebec County, including my beloved hometown of Winthrop. We also have Jennifer Griner with us today, committee clerk and secretary of the office, and director Peter Schleck, who will help us get through some of our work later in the day. Turning to the summary of our last meeting held on January 23rd, 2026, members will see in their draft document in meeting binders. And further, if there are no comments or proposed edits, that summary is considered final. Seeing no objections, it is so. Next, we have with us Public Safety Commissioner Michael Sawchuk, who has agreed to appear at our invitation and provide a briefing on civil rights and safety in Maine in relation to federal immigration-related activities. Welcome, Commissioner. You may begin with whatever statement you wish to make whenever you are ready, and then the committee may have questions.
Yeah, thank you very much. Good morning, Senator Hickman, Representative Mastracchio, distinguished members of the Government Oversight Committee. It's good to see you. Colonel William Ross from the Maine State Police will be joining me for this presentation, if that's okay with you.
That is perfectly fine, sir.
Perfect. Thank you very much. I know you have a busy session, a busy day. We do appreciate the invitation to come spend some time with you today. The clerk is helping us out by passing out this material. It's 22 pages. It's not dense. It's a lot of flow charts and stuff in there. We're going to kind of blow through this. But literally, as you know, we're here for you. So if you have questions reference to this or anything else, then we're happy to answer those. If we can't get you those answers, then we'll be happy to come back and provide that down the road. So again, thank you for having us. And I will dive right in.
Thank you, Commissioner.
So when we looked at the briefing request in that particular question, we kind of broke that down into 3 different levels. And I think the first one is like a Civil Rights 101 for Maine. And that talks about policy and training and some of the various outlets that allow not just the state of Maine, but nationally to deal with civil rights issues. There are those in the room that are far more expert at this particular topic than even us. But again, we're glad to be here for you to discuss those things. So when we talked about that, it's the policy training on the front end. We're going to talk about LD 1971 and our response to a federal surge in the middle. And then at the end, there's some investigative information in there, as well as I would call law enforcement referral style information. Things that come into us and then we refer out to other agencies, whether that's in this case, some of those federal law enforcement agencies that are in question. That page number 2, that talks about minimum standards for the Maine Criminal Justice Academy. Myself and the Colonel both are ex officio members of the Board of Trustees for the Maine Criminal Justice Academy. One of the things that we do as a board is provide minimum standards for policy for all law enforcement agencies across the entire state. There are currently 17 of those minimum standards, and I would describe those as heavy hitter style: use of force, domestic violence, hate and bias crimes. It's not uncommon to have a law enforcement agency with 100 plus SOPs, but these would be the 17, as an example, primary minimum standards that the Board of Trustees think are imperative that all law enforcement agencies across the state have. And so a minimum standard means that we're providing those baseline benchmarks for a particular topic. And the minimum standard I have in my hand is not part of your packet. That's literally the hate and bias crime standard through the board. And that highlights the importance of investigating all bias-motivated complaints, establishing procedures for bias-motivated incidents, thanks to the legislature requiring a civil rights officer in every law enforcement agency around the state. That was a legislative mandate and definitely something that was well received. And working closely with the Attorney General's office and local DAs, depending on what level of prosecution may be appropriate for a particular scenario. And the Colonel's going to touch on that a little later, but these things come in and go out from a bunch of different levels. Something may be appropriate for a local district attorney, while something should go to the Attorney General's office, in some cases to go to the U.S. Attorney's office. So we'll discuss a little bit more detail on that in a few minutes. As an example, on that page 3 that talks about the Maine State Police General Order, that's policy M5, that takes that minimum standard and turns it into an actual policy. And again, the key sentiments around that is protecting federal and state constitutional and statutory rights of all individuals. And we're going to have a slide here in just a couple minutes that talks about some of those protected classes. If you think about systems, you talk about minimum standards, model policies, and then departments taking those policies and bringing them home and making them part of who they are. So that page 4 talks about the model policy that the Maine chiefs created for all agencies to look at as a draft from that minimum standard. Again, the key sentiments are very, very similar throughout. The Maine State Police policy is 5 or 6 pages. Somebody else's maybe 3, maybe more, depending on what works for them locally and what they feel is important above and beyond the minimum standards provided by the academy. We talk about civil rights officers. We talk about training. That's really 3 different legs of that as well. So you have the basic law enforcement training program. That's brand new police officers that are at the academy. They are receiving hate and bias crime, civil rights training from the Attorney General's office as a block of instruction during that 18-week academy. And then you have civil rights officers. The manual, the training manual on that is a couple inches thick, as you can imagine. Very thorough training. They're going to be some subject matter expertise internally to a localized agency. So they receive standalone training through the AG's office, and then civil rights training in general. Every year, the Board of Trustees requires a certain level of training, and that may be 4 or 5 different topics at a couple hours apiece. So civil rights training, those updates have been provided over the last several years as well. So that's something that every officer around the state, approximately 5,000 between full-time and part-time, would be required to attend and to make sure that they're up to date on the latest information.
Commissioner, can you tell me what the duration of that block of training is? I think you said 8 weeks, or did you say 18 weeks?
So there's an 18-week Maine Criminal Justice Academy basic school. And in that training, there's a couple hours specifically to civil rights, hate and bias. And then after that, the civil rights officer training. Do you remember what that length was, Colonel?
I believe it's a 4-hour block of time, sir.
And then you have the updated trainings that are mandated, and those are generally a couple hours at a time.
Okay, thank you. Before you proceed, I'd like
Sure.
to ask a member who joined us from our late session last night to introduce herself.
Good morning. I'm Jill Dusa, and I represent Senate District 27, which is part of Portland, part of Westbrook, and for many years, the jurisdiction of our commissioner.
It's good to see you, Senator.
That is correct. And Senator Dusan was up late with the other committee we serve on last night as well. So good to see you this morning. I'm glad you were here. And I failed also to mention when we were in our memorial silence for Representative Evangelos, former colleague, that we have a new House Republican lead on this committee, Representative Chad Perkins. Congratulations and welcome to the leadership team of the committee. He's replacing Representative Lemelin, who was promoted, as it were, to be the House lead on the Committee of Health and Human Services. So congratulations to you as well, sir. Commissioner, you may proceed.
Thank you very much, sir. And I would also say that I had not heard of Representative Evangelos' passing. So my condolences to the committee and the legislature as a whole, and somebody who we worked with as well in my time with this administration, to say the least. My condolences.
Thank you.
If you look at page 6, enforcement, you talk about identifying, investigating, reporting information. This is a very high level review of civil rights and hate crime style offenses. And again, this kind of flows in all directions, right? You could go to a report that you think is a simple assault from some street on the sidewalk and realize that the motivation behind that was hate or bias related. And that's going to change the nature of your investigation to a certain extent and who you may refer that case to ultimately down the road. But this is pretty straightforward as far as identifying that you have a hate bias event, investigating that properly, and then reporting that to the appropriate authority. I did put LD 1971 in here, an act to protect workers in this state by clarifying the relationship of state and local law enforcement agencies with federal immigration authorities. I thought that folks may ask that question today, so I figured I'd just rip the Band-Aid off and talk about it. It was heavily involved with the legislature, lots of questions, lots of process, certainly within the legislature as well as in the communities that all of you serve and around the entire state. And I'll tell you right up front that law enforcement agencies were traditionally and originally opposed to 1971. And the reason for that is because we were concerned about communication. And any effort to curtail that communication between agencies can be problematic from an investigative standpoint, from a safety perspective. But I think looking at 1971 now, as we sit here in February 2026, I think of that as a rather myopic approach to communication. That was looking at law enforcement can't communicate with other law enforcement. So that's a primary issue. Communication certainly has a lot of different definitions. Communication from the legislature that voted to pass that. Communication from constituents and from communities to say that they thought that 1971 was important. Communication from the federal government and how they were going to prioritize immigration enforcement. Ultimately, with all those things in play, the governor decided to allow that to go into law. So as soon as that went into law, we went back really 9.5 months or so, because what I can tell you is we had a lot of information to say, well, how often is Maine State Police, as an example, involved in immigration enforcement? And the records management system that we have and that we utilize doesn't have that as queryable information. Like, hey, can I tell you how many times? It was 7 times, and this is what happened. That's just not the way the system operates. It's not even an option for us. So back in March of 25, we sat down as a group and said, we're getting a lot of requests about this particular topic, and rightfully so. We can't really give solid answers on straight up numbers about what's happening out there. So we put forward a directive, the operations manager, who happens to be with us here today, Lucas Hare, in concert with myself and Colonel Ross, just put out an order that said, listen, when you're involved in these situations, what I want you to do is check in with your supervisors. I want you to make sure that you have permission to do that. I want those reports by the end of the day. You're going to submit those reports, and that's just going to go up the chain so we can have some idea of what's actually happening out there on the street. And a lieutenant put that communication together, that went out, and we started to get these individual reports. So over a 9.5 month period, if a Maine State trooper, as an example, made a referral or reached out to immigration authorities for assistance in identifying somebody that they were working with, or making a referral, somebody was wanted, there was an issue that we felt we needed their assistance with, then that information would come back to us. So some context to this. Over that 9.5 month period, The Maine State Police, by far the largest law enforcement agency in the state, more than twice the size of our beloved Portland. In that scenario, they had about 116,000 total calls for service and traffic stops, combining the two of those, just about 50-50. Like one of them's 56,000 something, one of them's 59,000 something. So that's 116,000 plus calls for service or incidents where officers were responding to deal with a situation. Of that 16,000 plus, we made calls to immigration 63 times. So 63 times and 59 times, immigration actually came out to assist for one reason or another. So 34 of those 63 were commercial vehicle enforcement officers. They do nothing but commercial vehicle enforcement work. And they were identifying individuals that were operating without a commercial vehicle license. Bless you. So in those scenarios, we went back and looked at it, and simple cop jarhead math would tell you that that's actually 0.05% of our overall work during that 9.5 month period, rounding that up to 0.1, right? So I say all that because that provided context for us, and that provided some context to our officers to say literally, not hyperbole, hey, 99 times out of 100, this is data that came back in, and we would say 99.9% of your work is not going to change at all with 1971. But that 0.1%, the end of an investigative process where we would make a call to have somebody come in and assist on immigration, that piece is not going to occur moving forward. And that's the heart of 1971. We've never done proactive immigration enforcement from a local, county, state level. That's never happened in my history in the city of Portland. I haven't seen that. I don't know of other local, county, or state officers that are doing that work now. And so that's a baseline. And then saying 99.9% of the work you do, the discretion that we hire you for, the trainings that we give you will not be impacted by this. So I put a directive out on December 22nd and said that we're going to implement LD 1971 now and not wait until the prescribed time after the legislature adjourns. And Colonel Ross sent out a directive immediately thereafter, mine, DPS all, his to the Maine State Police. And that's how we got here. That's what that looks like today. And there's been some questions from the media and others about what that process looked like. And that's what it looked like. The legislature spoke, the governor used due diligence in her time ultimately to allow that to go into law. I reacted that accordingly from my perspective based on data that we had in front of us to react to that immediately rather than wait. And I will say that how's that different than this, to say red flag as an example? Red flag is a policy, right? A statute that's passed. Ultimately, that requires a bunch of different things: courts, process, forms, everything from soup to nuts to stand that process up. That requires training across the board, training that we're facilitating now. So that's not something I could just say, okay, well, I'm going to do that tomorrow. Because I can do it tomorrow, and this is a policy decision, something that I can control and something that I did control to put that into effect sooner rather than later. That doesn't mean that I still have concerns around the communication piece, because I do. Communication is key, but when you do look at this and you look at pros and cons, you look at risk rewards, you look at that communication that came back to us from constituents. That's why I made the decision that I did for 1971.
Commissioner, I'm going to ask if the committee has any questions
Sure.
on this topic. Are there any questions from the committee? Chair recognizes Senator Timberlake.
Thank you, Mr. Chair. Thank you, Commissioner, for being here. Really
Good morning, sir.
appreciate it. I think one of the concerns that I'd like to ask is, and I was trying to write it down, but I can't really. How will this change? My concern is, I had a brother-in-law who was a Border Patrol agent. How will this change affect the assistance that the state police has given the Border Patrol in the past? And the same as what the Border Patrol has given the state police in the past when we're out on rural patrols, because the bigger part of Maine's border is rural.
Sure.
And they kind of back each other up.
Yep.
And
absolutely.
so my concern is, how does this affect that relationship that we've had for the last 50 years, 100 years, whatever the number is, but it's been for eternity, basically, since the Border Patrol's been here in Maine. How does this new LD 1971 affect that relationship that we've had for years?
Yeah, so I think it's a good question, Senator. I think that for me, at this point in my career, I've said it 1,000 times, and I think the cornerstone of what we do on the law enforcement side is based on trust and relationships. You develop trust with those you serve and those you work with, and that allows you to develop the relationships that are going to make everybody successful. So relationships with our federal partners, just like any other entity that we work with on a regular basis, is incredibly important. 1971 speaks specifically to immigration enforcement. It does not speak to other forms of criminal investigations. It does not speak to human trafficking. It does not speak to domestic violence. It does not speak to some kind of a terrorism investigation. So the vast majority of times when you're talking about a backup situation, which we appreciate, and more importantly to me, I don't regulate anybody but folks that fall under DPS. But our law enforcement partners, especially from the northern area of the state, say they work with border protection, border and customs protection all the time. And they do it for domestics. They do it on regular traffic stops. So none of those things would be impacted. 1971 speaks primarily to immigration enforcement. So the valid question is, does that impact relationships? Just the fact that we're having the conversation in public and pitting entities against each other is probably going to have a negative impact on that relationship. But I do know that those relationships are strong in those local areas, because they're not doing, the local law enforcement, again, is not doing immigration enforcement. They're working with Border Patrol if they have an officer safety issue. And the other way, with 180 or so customs officers in the state, they are coming out and backing up local, county, state law enforcement all the time. And that's appreciated. So I don't see that piece being impacted at all by 1971.
Follow up.
You may proceed.
Thank you. And thank you, Commissioner, for your answer. But I guess my concern is, and I'm pretty friendly with a lot of law enforcement,
Sure.
and pretty friendly with a lot of the Border Patrol. Are you saying there is no change in the backup policy, that if Border Patrol calls, you're responding, and you're calling Border Patrol for backup for these troopers? Because I'm hearing there's a lot of concern with that, and I'd just like to hear you say that we're not doing anything that has changed any part of that.
So
In what we're doing, because I just, all I care is about, public safety, but I also really care about law enforcement safety. These guys are out there risking their life for me and the citizens of the state of Maine. And I do never want any one of them in the situation that they call for help and someone says, well, this is an immigration issue, so we can't show up, and somebody gets hurt. I mean, that's not going to look good. So I'm asking for that verification.
So what I would say to that, Senator, is that in my 30 plus years, I have never assisted with an immigration operation that was, I'm going to stand on a perimeter and help while somebody does an immigration operation. I'm not going inside a residence or a business and taking part in an immigration investigation. It's never happened in my career personally. I don't know of a scenario where it happened in a former agency in my time there. Certainly not in 7 years as a chief of the Portland Police Department. That didn't happen. They weren't asking us to go assist in that scenario, and we weren't doing that. If you're asking specifically about officer safety, there's a fight, there's an officer that's in danger, we are responding to that calls for service.
So, but the question I asked is, are we responding the same as we did before when they call for help, or are we questioning what they're doing before they respond?
I think we're responding exactly the same way, because they're not.
So
again,
nothing's changed.
They're not asking us for assistance with immigration. And if there's an officer safety issue, then we're going to respond. So I don't believe there's been any change in that regard.
Chair recognizes Representative Lee.
Really don't want to re-argue LD 1971. God knows we worked it
Yeah.
enough in judiciary,
Yeah.
but in that working it in judiciary, I thought we were pretty attentive. And there's two sections that I've sort of thought about, which are activities unaffected, which even allows for communication regarding immigration related information, so long as it's not part of an enforcement action.
Mhm.
We also included a number of permitted activities, which I think includes, and I want to know if you share my perspective, that it includes the activities that Senator Timberlake's talking about. We allow those to continue to occur so long as they're not about specifically getting municipal or state police involved in immigration enforcement onto themselves.
That's correct.
Thank you. Chair recognizes Senator Dusan.
Let me just say, Mr. Commissioner, that I appreciate your consistent affirmation of your leadership style, and the way you interact with the officers in your command around protect and serve means everybody. I wanted to just ask quickly, but you said you made some comments about credible communications. And I want to just state for the record, as I have from time to time, say that my reliance on observing you as a leader in enforcement activities, observing the members of your department, observing the members of the police, the Portland Police Department, is that I can feel confident in saying to constituents who might perceive themselves as more likely to have problems with law enforcement interaction than others, based on a variety of factors, including race or color of their skin. I have spent an inordinate amount of time telling people in domestic violence situations, in young immigrant men who are worried about being stopped by our police officers, that you can trust and listen. And when you're pulled over, I understand the panic. I have those talks with my son. But in my experience, and what I hope has been my son's experience over time, you don't have to panic when you see blue lights behind you, when you see red lights behind you. Remain calm, understand why you're being pulled over, and respond. That's not always been the experience in my lived history, in the history of my ancestors. So I just wanted to say that out loud in public, that in my experience, the department has been open under your leadership and others to concerns about profiling and what that feels like on the other side of the lights, to concerns about interactions and what that feels like from folks who feel at risk, like myself. And I appreciate your consistency on that. On 1971, my perception of that bill, I'm not going to redebate it, is that it essentially makes statewide policy what has been policy in the city of Portland for quite some time. I would like to be able to add to my conversations with others an example of what might have happened before 1971, and an example of that little category of cases that you're talking about, where it won't quite happen that way now that you're implementing 1971.
Yep. And very kind remarks, Senator. I appreciate that. I mean, one of the best parts of working at the Portland Police Department was the diversity of the community and building those relationships. And I think I look back on that today with great fondness. I think that when I use that 99.9% stat, right, that percentage, I think that let's think of a regular investigation for commercial vehicle enforcement as an example. So there's a way station lights are on. Commercial vehicles pull in to be inspected. As those officers, those troopers are doing their investigation and identifying the driver, they identify who that is. Maybe there's some concern over immigration for one reason or another. In many cases, it's trying to identify positively who are we really talking to here, and what does that look like? Out-of-state commercial driver's licenses and how that crosses over, and is this a valid license or not? Let's say that commercial inspector does something, finds out that individual doesn't have a license. They still use every state tool that they have available to them. They can use discretion to take this all the way to, I'm going to arrest the individual because they don't have a license, period. I'm going to tow their commercial vehicle. That's 99.9% of our regular investigative process. The very last step Maybe, well, now I'm going to call immigration and say, ask the question and then see if they want to come out to take custody of the individual. That's the last piece that does not occur under this current policy or under 1971. So all of your options are available as a police officer to do your regular job. It's just the last piece, that last referral, that last phone call doesn't happen. And it's the same way on a regular traffic stop. It doesn't have to be commercial vehicle. Does somebody have a license as an example or not? We're not calling immigration for translation services. They're not calling immigration for assistance for identifying an individual one way or the other. And more importantly, they're not making a referral to say, is this individual here legally or not? And are you going to come get them? We're not making we're not crossing that bridge. We're not making that request from immigration.
Senator may proceed with follow-up.
From the driver, from the perspective of the driver who's hopefully cooperating while your officers are trying to complete the identification process. If you get all the way to the point where you haven't made it confident, you're not confident in the identification of whom you have sitting by the side of the road, and you're not making the call to immigration, you have, however, sufficient information to determine whether you're going to take that person into custody or send them on their way. How does that happen?
So if an individual is going to attempt to identify themselves one way or the other, that could be verbally, they could give you a license. In many cases, from a commercial vehicle example, they're giving you a commercial driver's license from some other state. So we're going to use every tool that we have available, every lever we can pull, every database we can have access to. Right up until that line, we're just not going to make that final phone call to immigration. Thank you.
Thank you, Senator. Are there any other questions around this part of the commissioner's presentation? Seeing none, you may proceed.
Thank you, sir. Just two other slides that I'm going to cover before turning it over to the colonel. One, it's been publicly available through the media, was my exact email that I sent out as a directive on December 22nd. And that's followed by Colonel Ross's directive on the same day. So then I'll turn it over to Colonel Ross to continue with the conversation. Thank you.
Thank you, Commissioner. Colonel Ross, welcome.
Good morning, Mr. and Madam Chair, distinguished members of the Oversight Committee. For those of you that don't know me, I'm Colonel Bill Ross and Chief of the Maine State Police. The next part I'm going to talk about kind of dovetails off of what the commissioner had talked about communication. So we all came to know that January 19th through the 24th, ICE had ramped up a considerable Operation Catch of the Day, as they called it, in the state of Maine. The communication issues right out of the get-go is that we weren't, as a state agency, and nor were our local partners involved in any of the planning or any of the briefings prior to doing this. And you can point the finger to a lot of things. You could say, maybe 1971 contributed to that communication barrier, but it was a barrier of communication. We knew this was coming through open sources, through media releases, through press releases, through social media, and we made a decision that we were going to be proactive in ramping up to this and talking to our local partners. We can talk to Portland PD, Lewiston PD, Auburn PD, and we felt that these were the areas that seemed to be like where ICE had focused their attention. So we started out with conversations with them with the weeks leading up to this. Obviously, events that were happening around the country motivated those conversations. We wanted to make sure that none of that would happen here in Maine, or to the extent that that happened in other parts of the country happened here in Maine. So that was kind of the genesis of those conversations. We reached out to the Portland Police Department. I used to work with Portland PD, with the commissioner, very capable, very competent law enforcement agency. They said that they were all set and we would be in contact with them throughout the duration of our kind of pre-planned talks and during the week of the 19th. So we focused in on Lewiston and Auburn. Again, we have great working relationships with those police departments. We set up a meeting with some other law enforcement agencies and said, hey, this is coming. What are we going to do? What is it as the law enforcement community? Where are we going to be? And what we decided on, particularly with Lewiston and Auburn, is that we would form a unified command under this incident command model, and that we would work collaboratively to whatever came the week of the 19th. So we started to plan for something. We didn't know what the operation was going to be exactly, but we knew what we didn't want it to be. We didn't want this to look like what was happening in, say, Minneapolis or anywhere else in the country. So we brought in state police assets, and we had an agreement with these other agencies that if their agencies hit a capacity where they could no longer handle calls or things were escalating to the point where they needed assistance from the state police, we would be positioned to deploy our resources to help them. In the realm of possibilities, what does that mean? It could be anything from a minor stir-up on a street corner to a larger event to, God forbid, there's an officer involved shooting and we need to get resources there. Our objective for all of this was to have local law enforcement and their leadership on the ground communicating with our unified command. And if we were to deploy people, they would then make contact with the leadership on the ground. That takes away confusion, that takes away from chaos. And our objective was, and this kind of goes into the next slide, is to avoid deconfliction. Deconfliction is a cop term that basically we've been on two separate agencies showing up at the same area that don't know what the other one is doing. All right. So we want to make sure, at least on the state, county, and local side, that that's what we're doing. We know that if state police resources are being deployed, that they're being deployed at the request of a local law enforcement agency, and they're going with a purpose. So we've handled the deconfliction piece of that, and we're there to de-escalate. We're there to make sure that we're separating parties and to address anything that we might come across. And again, that's a pretty broad spectrum when you look at what's been happening in other parts of the country. But anytime you can intervene early and often, you can hopefully take the temperature down and make sure you have the right people with the right training that are there to intervene and de-escalate.
Chair recognizes Senator Timberlake.
Good morning, Colonel. Thank you for being here.
Morning,
It's
sir.
always good to see you. And I appreciate everything. In your comments you made and just thinking, and I'm a farmer, so I don't think this way all the time, but common sense tells me that I would want to maintain all communication I could make with everybody that I could make. So I would have thought listening to everything you said made sense, except for the point that we wasn't having communication with immigration.
Right.
That doesn't make sense to me, because even if you wasn't going to necessarily go and support what they was doing, I would have thought that you would have tried to have communication to at least know where they were and where you was going to be, so where you might possibly need to be ready. So can you explain whether you had that communication or not? Because I've been told from the inside that that wasn't happening. And I don't understand why we wouldn't. Communication is important. Okay, if we don't communicate, my wife and I fight real regular. When we do communicate, we fight more often, but we still communicate. And I think it's so important we have that. So can you explain why you wouldn't have that communication at all? Because that doesn't make sense to me.
It doesn't make sense. And I don't think we've seen this before. I've never experienced, and I've spoken to the commissioner about this and my command staff, where we've had a large increase of federal agents conducting a large operation in Maine where there's not a briefing, where there's not, I mean, particularly with the local law enforcement. If you're going into Portland or Lewiston, you have to communicate with the law enforcement officials on the ground. Maybe you don't have to communicate with the state if it doesn't involve the areas that we cover, but certainly those communication avenues need to be pursued, and they weren't in this instance. Believe me, we have a lot of people everywhere that are asking, but I think you have a lot of agents that are coming from out of state And I think a lot of these directives are coming from other than the local ICE agents or HSI agents that are in the state of Maine, to include Border Patrol. And I think that I suspect LD 1971 may have played a role in that. Although, as Representative Lee had mentioned before, there are stipulations in the law that say we can communicate with each other. But that was not happening. We did not have an operational plan, an incident operational plan from anyone from the federal government.
And I just want to, if you take a moment, Senator Timberlake. Colonel Ross, thank you very much for being here. Am I understanding you to say that the communication you did not have was because it was not initiated by those who were leading the operation into Maine?
Correct.
Okay. Senator Timberlake.
You're close, but I'm gonna spin it the other way. I think that, but did you reach out to them and ask for communication, and did they deny it? I think that's what I want to know.
We spoke to our local law enforcement partners. Everyone had reached out to their particular contacts, and no one had information, and they weren't providing information.
But did you, as the higher up or the state police, reach out to immigration and say, can you just tell us what your plans are? Did that happen?
I reached out to someone in HSI and said, here are the cell phone numbers of my command staff. Call us. We received no call.
That's the answer.
Okay.
Chair recognizes Senator Dusan.
Has your team had the opportunity to review or understand? I understand that our main systems include in their training de-escalation training and other techniques of trying to proceed with law enforcement in the safest way possible for both the perpetrator of some crime and the members of our law enforcement team. So I'm wondering, as part of the communication, at any point, are you made aware as of the particular training of the officers, the federal officers who might be coming to Maine? You know, do you get a chance to have a conversation between leadership around, here's our standard operating procedures?
Ideally, that's what would take place in a briefing. We would sit down, we'd talk about, hey, this is the operation. And then you consult with local law enforcement agencies or the state police, the county sheriffs. And that's a good idea, time to exchange ideas where you can say, you know something, that part of your plan, that doesn't make sense. That's not going to work. And de-escalation training and what type of training they have, I don't know. I don't know how many people they actually brought into the state, who they were, or what their backgrounds were.
You may proceed.
So essentially, someone's coming to my house but not calling me ahead of time.
You could put it that way, yes, ma'am.
And surprise incursion, the surprise of the visit might be one of the tactics of the visit. It might be an intentional tactic of the visit, which I understand, or is as best I can guess in terms of the goals of immigration enforcement, that, yeah, surprise might be one of the tactics of the visit, but it's not a tactic usually deployed in our day-to-day law enforcement.
In day-to-day law enforcement, no. I think in special operations that there's room for that. But what I mentioned before about deconfliction, that's why you talk to your law enforcement partners. So we all know what each other are doing, so we don't arrive at the same time. And, you know, bad things can happen if that indeed does occur.
Thank you.
I'm done. Thank you.
The chair recognizes Representative Mastracchio.
Thank you, Mr. Chair. So that lack of information coming from the federal government, is that still the status quo?
It is for us. We have yet to be informed of any other operations that are occurring. I can't speak for other local law enforcement agencies where there may be communications. I think we were fortunate, and I think a lot of things contributed to the week of the 19th. We didn't deploy anybody or any of our specialized units during that week. Lewiston was uncommonly quiet. Even though there were operations going on, we were not called by local law enforcement in that unified command. We were in daily communications with Portland. And I think that's a good thing that we weren't, because things did not escalate to the point where we were required to be there. But as we move forward and this operation is behind us, what the future looks like, I think with communication, that's where we need to do some work. And I think that's where the solution is to this, is that local, state, county law enforcement are all working together with the feds. I think that's the safest path forward. And that's what I would look to promote.
Thank you, Colonel. I want to just read these activities unaffected into the record and ask a question about it based upon Senator Timberlake's line of questioning thus far. And this is based on my understanding of what the operation was supposed to do. So in 1971, it says this chapter may not be construed to prohibit a law enforcement agency from sending to or requesting or receiving from an immigration authority information regarding the immigration status of a person, or maintaining or exchanging that information with any other federal, state, or local government entity under 8 United States Code Section 1373 or 1644. Or 2, it may not prohibit a law enforcement agency from investigating, lawfully detaining, executing a criminal warrant, or taking other action against a person pursuant to state criminal law or federal law. According to media reports, there were a number of people who were the targets of the operation. And it would seem to me that the federal agency might, under this law, reach out to ask for help in identifying maybe the whereabouts of the people that were on their target list. That's not prohibited in the law. And it's my understanding, Colonel, that you are saying that did not happen. No one asked for help trying to locate and identify the people who were on this list. Is that correct?
I can speak to that week with the unified command. We did not have any direct contact. And I can't speak for the local law enforcement agencies, but they were in the unified command with us. We weren't working off a list or an operation. We didn't have that, which you typically would have if we were involved in either the planning or the execution of an operation. So that's what was missing here. And that's frustrating on our end.
And so the lack of communication wasn't because you didn't want it. It just didn't happen from the federal agency down into the state and local law enforcement. Is
Correct.
that- okay. Chair recognizes Representative Lemelin.
Thank you, Senator. I guess Senator Timberlake and I are the only ones that are looking at this through a different lens. I respect and understand everything that's been said so far. However, personally, if I were the federal government and I know that the state of Maine is a non-friendly state to immigration as far as 1971 goes, and we have a governor, we have mayors, we have paid activists, and we have the press who is against us. And they will impede in our job of removing illegal immigrants. So, personally, if I know this, why, with 1971 involved, would I come to you and tell you I'm coming? Because that's going to be leaked out. Now I'm going to have to deal with Minnesota and have all the paid activists show up. They're in my face. They're ruining our cars. They're causing our job to be harder to be processed. People are going to get hurt. And it's going to escalate problems. So even though the number one thing I want is to contact you, I want you involved because it's safer. But 1971 says no can do. Yes, they can help out if there is a, if a person is a murderer, you can step in, that type of thing, but you're not going to assist in any way with the actual immigration process, which they need to get done. So they come in. I would personally do exactly what they did. Come in, take a look at the press. I watched Channel 6 News and there's 200 people apprehended. Channel 6 covers one person that was apprehended, released, and supposedly mistreated. Then they mentioned 2 more. So that's 3 people. I didn't hear a word about the 190 plus that were rapists, murderers, gang members. I didn't hear anything about that. Why would I, as the federal government, come to you or anybody else when you're non-friendlies? Do you understand my point?
I understand what you're saying. I think that's probably a better question for ICE's administration and the decision makers on their end. What I will stress is for officer safety, and I think the safety of everyone, leaving out local, county, and state law enforcement. We don't pick sides in this. We're there for the safety of everybody. And that's what our goal was during this week, was to have that safety net for our local partners if they found themselves at a point where they're outside their capacity. It would have helped tremendously if we had been more involved in the planning of an operation. I understand what you're saying and what your concerns are, but I do think that there is the bigger deconfliction piece is just as important, if not more.
What can you do? The scene happens, let's say the scene of Minnesota, okay? You've seen it on the news.
Representative Lemon, please defer. This is Maine. This is not Minnesota. Thank the Lord that in this operation that has come and gone perhaps, or ratcheted up and leveled off, we had no conflicts here in the state of Maine that looked like any of that. Representative Lemon, your question was asked and answered, and there are 7 people who would like to
Okay.
make more questions.
But
of
one
the
statement to
gentlemen
that,
that are here.
Senator, and that is,
Representative
I
Lemon,
agree with you.
Representative Lemon, please defer. This is a briefing from 2 excellent leaders in law enforcement, and the committee can discuss what we are hearing after. We're not going to have a debate with one another about our approach or our belief that this did or did not have anything to do with the lack of communication that is a problem here. So I'm going to move on. The chair recognizes Representative Lee.
Thank you. During Operation Catch of the Day, there was, I think, an unrelated arrest that was made in downtown Lewiston by, I think it was an operation of the U.S. Marshal's Office of Federal Law Enforcement in cooperation with state law enforcement. Am I accurate on that?
Mr. Chair, would you please admonish my seatmate to stop one minute right here?
Senator. The chair will pause for a moment. Did not realize that there is a member of our committee who is participating with us on Zoom. Senator Garin, will you please introduce yourself?
Hello, Senator Stacey Guerin. I did introduce myself in the circle, but then I had to leave and had permission to continue the meeting on Zoom.
That is correct. Can you please ask your question?
My question would be, what are the parameters for protecting the information if someone from the federal law enforcement contacts you and you said no one did, but if somebody had contacted you, what would have been the protection of that information that was received in that call?
We would consider that confidential information. We would share it amongst the law enforcement community as appropriate. That would not be something that would be publicly disseminated. And that protects the integrity of the operation and the safety of all the people involved, including the public.
Thank you. Representative Lee, did we interrupt your line of questioning?
Little bit.
Okay.
But I'll remind you of what the question was. There was I believe, an arrest made by the US Marshals in cooperation with either Lewiston PD or the state police during Operation Catch a Day, but unrelated to Operation Catch a Day. Am I correct in that?
I'm aware of that, but did not involve the state police. I
Okay.
believe it was Marshals and Lewiston PD.
Okay. And I'm not gonna ask you to chime in with your opinion on this, but if someone wanted a federal law enforcement operation to be disorderly, would not contacting local police and not contacting state police lead toward that end?
I think anytime you have a communication breakdown, that certainly could be a potential outcome.
Thank you. Chair recognizes Senator Tippey.
Thank you, Mr. Chair. Thank you, Commissioner Colonel, for being here. I have lots of questions, as the chair may imagine. But I wonder, I guess my first question, were you done with your briefing, or are we interrupting you with questions here? Do you have more you'd like to say?
Sir, I defer to you. Most of my briefing was going to be about the different referral resources when the public or anybody wants to report either civil rights violation or misconduct, that there's avenues that we are that are very well established, and I just wanted to point them out, but I defer to you.
I defer to the chair, if I
The
could
chair
wait on
would
general
like-
questions.
Please continue with general questions. I have a list of 3 other members, and then the Colonel can proceed with the rest of his presentation, and there may be more questions.
All right. Well, I guess, first of all, thank you very much, both of you, for being here. And I want to thank the administration in general for the response on some of these incidents. I guess I do have some concern of what we've heard so far, that there seems to be some talking about this as if it were a legitimate law enforcement operation that was conducted in Maine, and that the problem was not, enough communication or briefing or planning or coordination. I would just remind, the governor's statement was very clear that the operation inflicted pain and suffering on communities across the state. People have been terrorized, others have been separated from their children, businesses have been threatened. It's been due to ICE's lawless, dangerous conduct and their abuses of power, which are entirely contrary to good law enforcement practices and standards. So
Excuse me.
that is the,
Excuse me. There's been a point of order made from my right. What is the point of order, Senator Timberlake?
The point of order would be that the good senator is making statements that at this point in time, nobody's been even arrested, prosecuted, or said that anything they did was illegal. And he's making the insinuation that what happened with immigration was illegal and not, and I don't think that we got to make statements that stay within the boundaries of what we're talking about.
As I understand it, the senator is reading a quote from the chief executive into the record about the chief executive's opinion on the operation. And so the senator may proceed.
thank you, Mr. Chair. We're the Government Oversight Committee. It's our job to investigate the government and make sure that we're conducting ourselves appropriately here. So, given what has occurred, and what we've seen, we do have, the first and most important job of our public safety is to protect and serve, to protect the safety and the rights of Maine people. So I guess I'm much more, on the side of right now trying to figure out what happened, who was protected, how can we continue to protect people whose rights may be being violated. I have a bunch of questions, but maybe I can start with, we've talked a lot about 1971 and whether it's in effect or not, but just to be very clear, have any state resources, money, personnel, facilities, or property been used in coordination with ICE at all?
What's the time frame, sir? What are you referring to?
Let's say this year, but I'd be interested, what your thoughts are there, given the, what we're talking about.
So if we go back to the data that I relayed, if there were 63 contacts with Immigration and Customs Enforcement or with CBP, I can't give you a number of hours or exactly what that looked like. If that's what your question is, coordination with them, then in those scenarios before going live with 1971, we were reaching out to them to deal with real-time problems.
Okay, but nothing during the period that we were calling the surge here.
No,
Okay.
no.
And has ICE requested access to any state databases or government held information about Maine people that you're
Not
aware
I'm
of?
aware of, no.
Okay. We obviously heard many reports of people being detained or arrested, including US citizens. Many of these would be assumed to be a violation of civil rights. I know that's a big part of your briefing here, talking about those protections. Are you investigating any of those cases, or is there anything that you plan to be doing going forward about those apparent violations?
So the back half of this presentation talks about the proper referral tools. So what does that really look like? And if somebody contacted us as an example, it happens on a weekly basis. Somebody will call the front desk at DPS and say, such and such police department, fill in the blank. We don't like what they did. Can the Maine State Police do something about that? And there's a natural referral process back to that chain of command, back to that local government entity. It's a council, it's a select board. The chief works for the city manager, depending on what that is. So the referral here and in this presentation is around if you have a complaint, maybe that goes to the Department of Justice. Maybe that goes to the FBI to deal with civil rights violations in an investigation that are alleged. Maybe it's a 1983 action from a civil rights perspective.
Thank you. I understand there are pathways for reporting there, but we've also seen some, very public examples, with Juan Sebastian Carvalho Munoz, his car was left running in the middle of the street, his window broken. Does that something that you would investigate working with local police or not? Is there any way that you would be proactive in protecting people from these apparent violations rather than waiting for a referral?
Apparent violations. I think a problem that we're going to have here is that if we're asking local, county, or state law enforcement to step in after the fact with zero information at all about what happened, then it's going to be very difficult to us to investigate anything.
Well,
I will tell you that from a state and local perspective, the Board of Trustees came forward in 2020 and said that law enforcement officers, we have assertive language that said they have a duty to intervene. As an example, if there's two law enforcement officers dealing with a problem, something is criminal, immoral, unjust, they're like, so I'm right here, right now. I think that was always implicit in our training, in our conduct, in our policies, but assertive language saying you shall step in, you must step in and stop that from occurring and then report that accordingly, right? So that's a local scenario where I walk in with the colonel, we both are working a case, we know what's happening. If we're asking law enforcement officers to go in after the fact with zero information, I don't know what the expectation would be about investigating or making a determination one way or the other, whether the duties of the federal officer was valid, lawful, or not. I don't have any information to lead me one way or the other.
So, and I'll hold after this, and I know there are many others on the list, but when you say there's not enough information, but it's the position of your administration that there has been lawless, dangerous conduct and abuses of power. So I guess I'm wondering, there's obviously enough information to make that declaration, and what is going to be done about it?
I think that the AG's office has opened a tip line on that side of it. People are actively reaching out to federal law enforcement to deal with those issues. And I don't believe in any way that the Governor Mills, and she can certainly speak for herself, is viewing these things and reacting to those things. I haven't heard her say that the local, county, or state law enforcement should be stepping in to intervene in the middle of some situation involving a federal law enforcement.
I'm talking about now. If there's abuses of power, are those going to be prosecuted or investigated?
They would be by the federal government. That's correct.
By the federal, okay. Thank you.
How do you define an abuse of power? What exactly does that mean?
Well, I guess I'd ask the governor that. That was her language.
Senator Tipping, is that a request for the governor to come and answer these questions? Because
I'm not making any
you really can't
requests, but
expect
I'm
the
just trying to
Commissioner
figure out what
of
we're doing here.
Public safety to speak for the governor who can speak for herself. This committee has the ability to ask her to join us at any point in the future, or we can certainly send her direct questions in writing if we would like for the governor to answer them. But the commissioner and the colonel are with us today. And I'd like to focus on their presentation to us because this is happening at your request, sir. Chair recognizes Senator Doosan.
there's a lot that I let go by, many rabbit holes that I jump over. So not to devolve down into an ugly back and forth. I did for the first time hear an assertion on the record a few moments ago, and I wanted to make sure that there is at least a uh, contravening opinion on that matter, and that is the assertion that the suggestion that if our state law enforcement leadership were briefed about an impending immigration enforcement action, that you would leak that out to the, I'm not sure how many words were used to describe advocates or immigrants advocates. But would your office call up the Press Herald? Is it the case that, you know, tell Colonel Ross, tell the Press Herald? I mean, I have never heard that assertion before, and I was personally insulted by that attack on your integrity, and just felt I had to put something opposite in the record.
We love our friends in the media,
Yeah,
but no,
I
no,
would
we would
not
not
tell
be
them that,
reaching
no,
out to
no.
tell them what's happening. No.
Point of order.
Laughter is the best medicine. Senator Garin, what is your point of order?
Senator Newsom, I believe, is referring to the question I asked about the security of the information that was asked.
Senator Garin, I don't
Yeah.
mean to cut you off, but that is not exactly what Senator Dusan was referring to. And so if there is a specific point of order that you would like the chair to rule on, and you please state what that is.
Are you saying she did not say that I was inferring there would be leaks from the department, because I was asking about the procedure for who would find out and how that information is protected?
I'm going to allow Senator Dusan to directly answer your question so that I'm not interpreting her words. Senator Dusan.
Thank you, Mr. Chair. Thank you, Senator. My comments are referring to the comments made by my colleague to my left. I get my left and right mixed up. Just before your question, in fact, I believe his comments triggered your question. I appreciated your question. And the specific, if someone is keeping track of the record, he absolutely made a reference to what would happen with information shared with the state police department if ICE were to brief them on an impending operation. That's what it's the first time I heard something like that in all of these very contentious conversations, and I felt the need to speak to it. I appreciated your question. It was a more succinct way of getting to what exactly was said just before you asked your question.
Thank you, Senator Dusan. The chair recognizes Senator Timberlake.
Thank you. Thank you, Mr. Chair. And I'm referring back to a comment or question. I guess it was a question that the chair had asked you earlier about, did they reach out to you? And my question is to you, if they, meaning the immigration department, had reached out to you, would you have worked with them or would you have not worked with them? And because I would like to know that answer, because I'd like to pass that message on, that in the future, because we know there's going to be a future of them coming back here. If they reach out, are you going to work with them, or are you going to say, I'm sorry, we can't help you? You're in this by yourself.
No, absolutely. We would meet with them, collaborate with them, and exchange information with them. And depending on what their operation and the intent of their operation was, would determine what our next move would be. But absolutely, communication with a federal agency, I think, is paramount, particularly if they're conducted in operation in Maine. So yes.
And that communication is not prohibited by law. The chair recognizes
you.
Representative Eder, and then we will allow the colonel to finish his presentation. And if there are more questions, we will take those at the time. Representative Eder, the floor is yours.
Thank you, Mr. Chair, and thank you, Colonel, for your service to the state. I think the senator already addressed most of the question I had in mind, but the concern for me remains going forward about this gap in communication. It must have been very frustrating for you to have operators in your jurisdiction without any communication. What do you, and I don't know if that came about, as has been discussed here, via 1971, looking with an eye toward the future and potential for any difficulties with that situation. Did you feel at all, you talked about your efforts to reach out. Is there a normal process that would be followed? Was any of the normal process that would be followed from your side of the communication line at all changed by the legislation 1971? And what would you do in the future, or what would you recommend to increase communication and have a better understanding about the operation?
Thank you for the question. I think, as the commissioner had stated, communication is key, no matter how it happens. You continue to try. We also have local partners that we work with, and moving forward, communication will be critical on all aspects of what our operations and whatever their operations are going to be. Anytime we can get together, we're going to strive for that, and that means if it involves including our local partners, because that's where it's happening too. Local jurisdictions are probably going to hear about ICE involvement before we are, just because of the lay of the land and how we're positioned operationally. But again, connecting with our local partners, and anytime there's an opportunity to have that discussion, we're going to.
You may proceed.
Thank you. And just to clarify, was there anything in the legislation that interrupted a normal flow of communication between those different agencies?
1971, as it's written, would not interfere with us communicating with them, unless it involves explicitly immigration enforcement. So we would be able to have conversations with them.
Thank you. Colonel Roth, appreciate you answering all of these questions in the middle of your presentation. You may proceed.
Well, thank you, Mr. Chair. A lot of it has been covered in some of the questions, but I'll go through it rather quickly. But the next slide, which I think is 13, talks about the Maine Human Rights Commission, the Attorney General's Office, and local law enforcement, particularly as it pertains to civil rights officers that the commissioner had mentioned earlier. Every agency is supposed to have one. We have many civil rights officers that will conduct investigations, and they'll make a referral back to the Attorney General's office and the AG's office. They'll make the determination as to what the direction of that investigation is going. Will it go back to a DA's office for a Maine criminal law, or will it be something that'll be referred federally to, like, Department of Justice? So that's what that is, and I'm going to go through these somewhat quickly because I think we've talked about a lot of them.
Mm-hmm.
In Maine, when you talk about investigations that some of these civil rights officers or any law enforcement officer might come across, if it's a violation of Maine law, and there's a bias motivation to the crime, again, the same type of investigation, you identify it, you investigate it, you report it to the Attorney General. It may come back to the primary agency that took that call and work with the attorney or the district attorney's office. If it's like a crime of assault, they would take that through the typical court process, with the standard being beyond a reasonable doubt. And then the civil rights violations would potentially be handled through sentencing provisions, which has a lesser burden of proof. And that's not necessarily unique to Maine, but not all states have that. Some states implement hate crimes, which needs a burden of proof of beyond a reasonable doubt. Maine has that sentencing provisions, which is I think a much more efficient way to handle these types of cases. So that's what slide 14 talks about. Again, I'll skip right through 15. It talks again more about the Human Rights Act, which oftentimes deals with employment, housing, and other types of discrimination. Civil rights in schools as a civil rights team project, which I'll skip over that. All of this is available on the Attorney General's website and easily accessible. So I move to the next slide, which is investigative civil rights on the federal level. Department of Justice, their Civil Rights Division would be the prosecutor's office that handles any civil rights violations whether it's a violation of criminal law or civil law. They typically use the FBI to conduct their investigations. The federal government also has the Equal Employment Opportunity Commission and the Office of for Civil Rights, which handles Title IX, dealing with schools and universities. So that's just kind of a quick overlook on what these agents, and these are the avenues that we would be referring to conduct these investigations, particularly if it involved federal agents, if it involved federal crimes, or involved misconduct of law enforcement that had a nexus to civil rights violations, either by an individual or if you have an agency that has a practice of discrimination or civil rights violations, the Department of Justice, the Civil Rights Division, they can bring forward a consent decree, which essentially they take over a law enforcement agency's operations and try to fix the problems that are there. I know that was a pretty quick hit, but we've got this for you as a resource. Certainly look at the AG's website or the Department of Justice website. We got a tremendous amount of information. The next slide, the commissioner had mentioned the Attorney General's office had established a dedicated email to take complaints. And this was as a result of, I think, two things that were happening around the country and potentially things that may have happened during the week of the 19th. I checked with the Attorney General's office to see what they have received for emails and if they have any investigations. Currently, right now, we are not conducting, as the state police, any investigations in coordinating with the Attorney General's office. The next two slides are essentially law enforcement misconduct, the federal statute, which is what I explained before. 18 USC subsection 242 is law enforcement misconduct. And I explained that, typically that would go make a referral to the Department of Justice Civil Rights Division, investigated by the FBI, and it could go after the individual in this particular statute. And then there's other statutes that would handle a police organization if it was that type of a problem. Again, the next slide pretty much talks about the same thing, that if you have a problem with a federal law enforcement officer, if someone wants to make a complaint on a federal law enforcement officer, there is this well-established process through DOJ, using the FBI as the investigators, to kind of conduct that investigation, determine whether a crime has been committed on the federal level or a civil violation of civil rights. And they have remedies to all of that, which could be anything from a criminal prosecution to leveling some type of fine or discipline. And the last two pages it's a screenshot from the DOJ's website on how to make a complaint. It's very easy to do. Again, this is something that if complaints come into us, comes into the AG's office, oftentimes they'll end up in the DOJ's house. Sometimes they'll come back down to the state level. And what they want to do is they want to take the complaint and the investigation, which jurisdiction is best able to handle this. And that depends on the information they have, the type of crime or civil violation that's been committed. It gets pretty complicated, but there's a big group of people that are looking at it, and there's different houses for this. And I think that that's what we've been able to show here. And lastly, U.S. Immigrations and Customs Enforcement. Misconduct is just like the state police. Maybe not there's a violation of law or a violation of civil rights, but there may be misconduct. There's an opportunity for people to make a complaint on misconduct, just like you can for a state trooper. Or you can, give an attaboy to a state trooper too. We'll take those as well. Thought I'd get that in there. But, and these are, again, easy access to the website, easy access to make your complaints. And it's information that I think most of us know or are aware of. But I think it's important to highlight it, that these are the processes we have in place. The good thing about processes and policy, They can be adapted, they can be changed, they can be modified. And if there's good reason to do it, then, those things should happen. But that's what's there. And my experience has been that these processes work and these processes are well established. Not that they can't be better, but they do work.
Thank you. The chair recognizes Representative Strachan.
Thank you, Mr. Chair. So I just want to, I'm looking at the law enforcement misconduct statute. That's the federal. Maybe it applies to everybody, but it looks like this is under the federal law. And I'm looking at the Maine civil rights that it says that all people, not citizens, not residents, it says all people living, working, or visiting in the state of Maine are protected. And it says the same thing. It says that all persons in the United States in their civil rights protects them and furnishes the means of their vindication. So I'm just trying to establish we are protecting, you protect everybody who's in this state. And I guess I know that in my community, there were people, all the people that were targeted were definitely subject to the bias that because I know who they were and I know they were all here legally, but that legal status doesn't, if illegal, legal, there's still people here who are protected by our Constitution. Correct?
That's absolutely correct.
Correct.
Thank you.
The chair recognizes Representative Perkins.
Mike and I are gonna fight forever, I think. No, it's on now.
It's on.
Thank you, Mr. Chairman. I'm going to make just a small indulgence. And thank you, Colonel and Commissioner, for being here. Thank you very much for the professionalism and in both the presentation and the preparation of what you've given us today. But I gotta be honest, Mr. Chairman, I struggled a little bit when we had the request for this presentation, not in the that it wasn't useful, it was extremely useful, but just in its relevance to our mission. I heard today in the committee that, we are the Government Oversight Committee, and I agree with that, but I think that we have a very specific task and a mission and a charter to look over our state government, not the federal government.
Correct.
And I entrusted I gave deference to your wisdom and your judgment in allowing this in front of the committee, of course, but what I witnessed today, to be honest, Mr. Chairman, is I've seen this turn into a political cat fight, and it's been very disappointing to me. And while I think that maybe something like this would have been more appropriate in my other committee or maybe in the judiciary or something like that, I think that today has really diluted our mission and distracted from our mission. And I just wanted that on record.
I don't disagree with you, sir. I believe in free speech, and I do understand your point entirely, which is why I want to keep the focus on the gentlemen who have been invited to talk to us and to understand how they are dealing with the changing landscape, the current landscape, and what processes, procedures they have in place to protect the civil rights of all people who are residing in the state of Maine. So I appreciate your remarks, Representative Perkins, and it's up to each one of us to honor our mission on this committee. There are clearly disagreements about the law. We debate those elsewhere. And that's for all of us. The law is the law. We should know what it is and we should know what it isn't, what it allows for and what it doesn't allow for. And talking about things that the law say are absolutely allowed for. So I read that section into the record so that when people say that they can't communicate, that's not what the law says. So let's stick with the letter of the law and let's listen to our commissioner and our colonel tell us how they are interpreting the law and what is impeding or helping their work. And with that, the chair recognizes Representative Lemon.
Thank you, Senator. I just wanted to go on the record and let you know that my statements in no way were challenging your integrity. I believe both of you have very high professional integrity. And I don't believe in any way, shape, or form that if I had contacted either one of you, that you would have leaked out any information, and I'm positive you would have told you the command below you that they are not to leak it out. I get that. However, I was trying to give a different point of view to have some of my members here understand why ICE may not contact you. And that even though nobody in your command would leak it out, it could get out. And I think that's something that ICE had to think about. It was just a point of view. I don't know. I'm not in their shoes, but that was my thinking. And believe me, it had nothing to do with your integrity in any way, shape, or form. And I just wanted that on the record. Thank you.
Thank you, Representative Lennon. I am reminded now of the Toltec adage that we must be impeccable with our word, and we must not make assumptions. And I think that the gentlemen before us have done a very good job. There may be more questions about what is in this today. If we have follow-up questions, we can always write and send them. But we can never make assumptions about what motivates anyone to do something or not, unless they're the ones sitting in front of us and we're asking them the questions. This is not oversight for a federal agency, as Representative Perkins said before he left the room. And so there's not a whole lot of need for us to imagine what ICE may or may not have felt. This is about the state government and the role of our leaders to protect all of the people who live in the state. And with that, the chair recognizes Senator Tipping.
Thank you, Mr. Chair. And I think my first instinct of letting you keep going with the briefing was the right one, because you've answered many of my questions here. So appreciate that. And I didn't want to get in a back and forth on anything, but there do seem to be some blurred lines here about different federal and state and local responsibilities and things that aren't clear, as we've seen in other states. So just to clarify, you said that, any prosecution would be, or investigation would be the job of the federal government. And you mentioned that you've been in touch with the Attorney General regarding the tip line, and there's no investigations coming out of that. Obviously, what we've learned over the last few weeks nationally is that if there are state crimes that fall outside official duties, there may be responsibility to investigate or pursue those. Realize you're not the Attorney General and not making decisions on prosecution, but just to be clear, you've not seen anything at this point that you believe would require that investigation within the state of Maine.
It's an incredibly broad question. I don't know exactly.
Yeah.
If you can narrow it, I'm
I guess-
happy to help, but.
And I realize it's also not something you can talk about necessarily if there are ongoing investigations, but I guess I'm asking, in broad terms, can you say, is there anything you're investigating as a potential state crime that's arising out of what we've seen recently with ICE's conduct in Maine?
No.
Okay, thank you. We saw recently there was a legal memo from ICE that they claim the right to enter homes without a judicial warrant. Have we seen any reports of that in Maine?
We have not received any of those reports, sir. And I should go back to the last question you had,
Okay.
just to say, though, from a jurisdictional standpoint, like an example, like there was a car parked and the windows were down. We handle certain areas of the state, and then there are law enforcement agencies that cover the area where that actually occurred. So there may be something happening at the local level I can't speak to, but I did want to clarify that. We cover a lot of stuff, but there's a lot of communities, obviously, that have law enforcement agencies that have that direct jurisdiction, that direct responsibility that we may not be involved with at all, or we wouldn't know necessarily if they were doing something one way or the other. But
Appreciate that. We've also recently had some federal judges that ruled that ICE must provide detainees with immediate access to legal counsel, and that they haven't always been provided that right. Are there any steps they're being taken on the state level to ensure that people detained in Maine jails have that right?
So the Department of Public Safety has zero jurisdiction over correctional settings.
Right, I understand that, but
We're
you're,
Federal judges' decisions, Fred, I can't answer that, sir.
I'm sorry, I should clarify. I'm asking that more in the kind of liaison role that you're playing with local authorities as well. Has there been any conversation about that?
Not that I
Okay.
know of.
And one more question, then I'll get back in the line here, if that's all right, Mr. Chair. Maine's Fusion Center, the Maine Information and Analysis Center, how has that been used during this time? And if, have there been reports circulated about ISIS activity in Maine?
No, to my knowledge, there's been no reports from the MIAC reference to ICE activity. Just quite frankly, we don't know what that activity is, so there'd be nothing for us to report out on.
Okay, thank you.
Sure.
Any other questions from the committee? Chair recognizes Representative Lee.
Has it been your experience that previously federal law enforcement would communicate with state or local police if they were doing an operation, even if they didn't want those state or local police to be involved in the operation itself?
I would say that as a general rule, we have outstanding relationships with our federal partners across the state. They had an FBI office in the Portland Police Department, still there. At this point, it's 15 years it's been in the building. So those relationships are very, very strong. I do think that, again, depending on where you are in the state, some activity may be different. It may be CBP more proficient in Aroostook County versus someplace else. The FBI and DEA are constant players in joint investigations with Maine Drug Enforcement and others. So that, those avenues of approach for communication continue to be strong to this day. Yep, sure.
Thank you. Any final questions? Chair recognizes Senator Tippett.
Final question. We've heard, and the governor said recently that we don't know, quote, critical details about the 200 individuals ICE says that it's detained, many of whom who appear to be here legally. People may deserve to know the identities of every person taken from here, the legal justification for doing so, where they're being held, and what the federal government's plans for them are. I wonder, again, maybe not directly in your purview at all times, but if you can speak to any actions that have been taken to try and find out that information or the status of these people. I also wonder if you've had any reports of children that have been detained in Maine.
I don't have any of that information, Senator. I know that clearly you're reading some quotes from the governor and her outreach to the federal government to try to get those exact answers. I'm not involved in those conversations, or if there have been responses, I'm unaware of that.
Okay, thank you.
Sure.
If I may add one thing, if you go to the last page, the ICE website has detention removal information tip line. I can't guarantee what you're going to find on the other end of that, but that's certainly a resource that's available.
Thank you, Kurt. We appreciate you both being here today, Commissioner, Colonel. This was an instructive conversation. What Representative Perkins said notwithstanding. So I appreciate you sitting with us through all of that. If we have follow-up questions, we will submit them to you in writing and will not necessarily need to call you back. But we do appreciate you being here, bringing your team, and making us aware that you do believe that all persons in the state of Maine must have their civil rights protected, and you're doing your best job to ensure that that is the case. So we appreciate your work, keeping us safe. Continue forward.
Thank you very much. Yeah, we appreciate the invitation. It's good to see everybody, truly.
Yes.
And good luck with the rest of the day. Thank you very
much. Our agenda is full, but we will take a 5-minute break before we proceed to hear from the leaders of the Deputy Secretary of State and the Bureau of Motor Vehicles. Committee will be at ease.
I really don't have much.
The committee will be in order. Welcome back to the Joint Legislative Committee on Government Oversight. We now turn to a return visit from senior leaders in the Bureau of Motor Vehicles who may have additional answers to questions posed by members of this committee at our meeting on December 17th, 2025, concerning controls over the issuance of driving credentials. Good morning. It is still morning. Welcome back to the committee. Please introduce yourselves, and I'll let you make whatever statement and however you would like to answer the questions that we have prepared for you. The committee will be in order. Thank you.
It's his fault.
Please proceed.
Good morning, Senator Hickman, Representative Marasco, and members of the Government Oversight Committee. I'm Kathy Curtis, Deputy Secretary of State for the Bureau of Motor Vehicles, and I'm a resident of Winthrop also. Joining me is Chris Ireland, Director of Driver License Services here at the Bureau of Motor Vehicles, and he's responsible for the overall administration of our driver licensing and identification programs. And he's a resident of Pittston. I'm sorry, Pittston. We appreciate the opportunity to address the questions that you outlined in your letter dated January 16th. You've received our written response, and I'm happy to walk through those questions with you today if you would like. You turn to your letter, you'll see in the very first paragraph that we want to define our mission at the Bureau of Motor Vehicles, and it's to protect public safety on Maine roadways. We are committed to continuous improvement of customers' experience by improving accessibility and reliability, to improve positive employee experience where our employees are experts, valued, and empowered to serve the public, to invest in trusted technologies to improve efficiency and security. And we are committed to ever safer roadways by supporting improvements to our driver education, driver behavior, and vehicle safety initiatives. Roadway safety is our North Star. We're proud of our ongoing work to safeguard the integrity of our programs and the safety of our roadways. Every roadway fatality is a tragedy, and our hearts go out to everyone who has lost a loved one in a crash. Pursuant to your request, I'm happy to provide the following information to answer your questions about driver education and driver licensing in Maine. Your first question to us was, what's the pass rate of immigrants who bring interpreters? Our answer is, broadly speaking, statewide pass rates of the written exam for customers with an interpreter are consistent with pass rates of customers who do not have an interpreter. Of the total 13,889 non-commercial driver license written exams conducted across the state in 2025, 72% of the applicants passed the exam. For the 2,416 applicants with an interpreter, 70% passed the written exam during that same period. Your second question was, are there statistical differences in the evidence of cheating between citizens and non-citizens who are trying to receive a permit or a license? This is an area that we don't collect data. We don't have an answer for you, but I can tell you that if an examiner suspects cheating, they are empowered to stop the exam. Going on to your third question, how many interpreters brought in by the applicant seeking a permit fill out the 81 form, the form with their credentials? Are interpreters paid by the applicant for their services? And how often do individual interpreters provide their services? All interpreters are required to complete an MV-81 form prior to providing translation services during an exam. Driver license examiners capture those forms, which are scanned into our driving licensing system and attached to the applicant's record. We do not capture any information on fees charged or paid by the examinee to the interpreter for their services. That's a transaction between them. In 2025, we supported an average of 264 interpreted exams every month statewide. This includes all languages, including American Sign Language requests, as well as accommodations for various learning styles. Your fourth question was, what's the difference between fraud and cheating? We are unaware of a uniform definition of either fraud or cheating in Maine law. Rather, these terms are utilized. If these terms are utilized, they depend on the statutory context. For example, cheating is not addressed in motor vehicle laws in Title 29A MRSA in the specific context of driving examination. That being said, we have identified the following examples of how fraud is defined. 29A MRSA Section 2103 defines crimes associated with fraud and falsifying on documents submitted to the BMV. One provision states that a person commits a Class E crime if they knowingly make a material misstatement of fact on an application or document submitted in the support of an application for a license, certificate, permit, examination, identification card, fuel use decal, placard, or any other document requesting action by the Secretary of State. This limiting language refers to information provided on a license application, not necessarily the conduct in the exam room. BMV requires exam interpreters to complete the MV-81 form titled Oral Test Attestation as part of each exam they support. On the MV-81, the interpreter certifies that the answers given on this examination were supplied by the applicant and that no answers were given or corrections made by me. I'm aware of the statement on this form are punishable under the provisions of 17A MRSA, Section 453, as a Class D crime. And that section states a written false statement, which he does not believe to be true on or pursuant to a form conspicuously bearing notification authorized by statute and regulation to the effect that false statements made are therein punishable. You asked a similar question under number 11, so I'm going to provide some more detail that will bring this information into a little bit more clarity.
Thank you.
The question 5 is, what is the permit test pass rate for those who take driver education? We don't collect the information related to written exam pass rates for students who take the written exam via a licensed driver education program. In Maine, driver education schools administer the written exam to students on behalf of BMV. The BMV issues to the licensed driver ed schools multiple versions of a written test to allow retesting should a student not pass on the first attempt. BMV only receives the course completion notification, which includes successful completion of a written exam. So if a person is taking the exam multiple times, we don't know that. Question 6, does the department accept a summons to a court date, even a summons for a removal process, as valid documentation for legal presence in issuing driver permits in the state of Maine? As directed by statute in 29A, BMV reviews and confirms legal presence before issuing a non-driver identification card or driver license. BMV does not review or establish legal presence as part of the Class C driver license permit process, considering the driver permit is not an identity document and does not convey to the holder any privilege other than the right to learn how to drive under adult supervision. Currently, legal presence is reviewed after successful completion of the road test, when the customer returns back to our branch office to have their photo taken and to have their driver license issued pursuant to 29A MRSA Section 1301. Now, in the summer of 2025, we identified a plan to adjust this process to make a legal presence determination earlier in the Class C driver license permit process. The change is important but substantial and will require some modification to our digital driver license system. The project is currently slated to start after we modernize our digital license system this coming June.
The chair recognizes Representative Perk for the question.
Thank you.
Later.
Later. Thank you, Mr. Chairman. Thank you, Deputy Secretary. So I just want to make sure I understand your answer to number 6. So for a permit, not a license, but per permit, you do no verification on legal status. Is that correct? But for a driver's license, you do.
Yes,
But what you require to establish legal presence is established by rule and not by statute. Is that correct?
it's established by state and federal rule and law. And we actually identify that a little later on in my remarks.
Okay, I'll wait, maybe
Yep.
and ask again. Thank you.
Okay,
Thank you. You may proceed.
okay.
Chair recognizes Representative Lemon.
Just one quick question, under number 6 also, how long can they drive on that permit once they receive it?
2 years.
Thank you.
Thank you.
You may proceed, Deputy Secretary.
Moving on to question 7. Have real IDs been issued based solely on someone having a EAD, which is a employment authorization document? We adhere to all federal requirements when issuing a real ID. In fact, TSA authorizes state licensing agents to request certain exception policies for TSA approval. But in the 6+ years that we've been issuing real IDs, we have not pursued any exceptions. Our training products explicitly call for a second document if an employment authorization document is used. And a record of a pending asylum application would count as provided with an EAD in certain circumstances. This is aligned with the federal government's real ID requirements. Question 8. What constitutes substantial evidence of cheating on an exam? Our examiners are empowered to stop an exam if they have reason to suspect the applicant, with or without an interpreter, may be cheating. We expect our examiners to handle that situation professionally and to report the matter to their supervisor for follow-up and review. As outlined above, Maine law does not define cheating in the context of driver education. I do want to say our department stands ready to work with the Transportation Committee in the 133rd Legislature to propose changes in the law with regard to applicant cheating.
Chair
Question,
recognizes Senator Dusan.
I'm sure it's here. I just want to make sure I understand. The non-driver identification card is a real ID or it is not?
it can be either or. So it can be a real ID card or it can be a standard identification card.
And to make that distinction, the applicant would request that it be a real ID.
That is correct.
Thank you.
Thank you. You may proceed.
Thank you. Question number 9. Does Maine use all the standards that the federal government requires or only the EAD standard? As outlined above, BMV follows the federal Real ID law without exception for issuance of Real ID driver licenses and identification cards. We require a second document if the EAD is presented. Question 10. Are you aware of any evidence of difference in accident rates based on immigration status? Looking back over 2025, we can see that 62,152 Maine drivers were involved in a crash. And I want to point out that that doesn't mean that they caused the crash. It was just that they were involved in it. Out of a total population of 1.2 million Maine permit and license holders, we found that limited term non-citizen drivers in the BMV computer system were involved in 989 crashes in 2025, representing 1.5 of all drivers involved in crashes in 2025. Going on to question 11. If an interpreter is signing the MV-81 form stating they're an interpreter with integrity and they were cheating, wouldn't that be a form of fraud? Yes, yes, it would. BMV requires all exam interpreters to complete an MV 81 form, as I said earlier, titled Oral Test Attestation, as part of each exam they support. On the MV 81, the interpreter certifies the answers given on this exam were supplied by the applicant and that no answers were given or corrections made by me. I'm aware that false statements on this form are punishable under Title 17A. As noted above, Title 17A, Section 453 establishes that a person makes a written false statement when he does not believe to be true or on or pursuant to a form conspicuously bearing notification authorization by statute or regulation to the effect that false statements made therein are punishable, is guilty of a Class D crime. This is the important fact. In order for the Bureau to hold accountable an interpreter or examinee under these sections, the guilt of the individual in question must be determined by a court first. Section 12. Do you have a record of the investigation of an interpreter cheating that was completed under the previous Secretary of State that the committee could see to determine if the committee believes it's thorough enough for the purpose of this conversation? Yes, and in fact, you've been provided with copies of 2 investigations that were done by the previous Secretary of State's administration. Question 13. Do you collect any data on the number of permitted drivers who have an accident while in permitted status? Yes, all crashes are recorded in the Maine crash reporting system and are digitally transmitted to our computer system and applied to the appropriate driver's record. If you'd let us know if you'd like this data and for what period. This is not a typical report that we have available, so it will take some time to extract that data. But we'd like to know, but we're happy to do so if we are can limit that to what exactly you're looking for. Question 14, has anyone in the state of Maine, as an asylum seeker, who only had a petition for asylum and a work permit, been allowed to obtain a real ID? Yes, as I said earlier, Maine follows the federal law established by the Real ID Act, which permits asylum seekers with a petition for asylum and a work permit to hold a Real ID driver's license. Question 15. If an individual has an H-1B visa and applied for a Real ID, would that person be authorized for a Real ID under the current process? A standalone H-1B visa by itself is generally not sufficient proof on its own to establish legal presence for a Real ID. An H-1B visa in conjunction with a foreign passport with the visa and an I-94 that reflects admission and status is acceptable per TSA regulations in the Real ID Act. I hope these answers have been useful for you. And I'd like to conclude my thoughts by telling you, we are proud of our work to provide oversight to the driver education programs and ensure these programs and driver licenses are issued in strict adherence to federal and state law. We retain an immigration attorney to answer queries for our staff on a regular basis and to audit our records to identify and rectify any errors. We implemented a rigorous training program with our 2 staff trainees who work directly with our frontline staff to learn the laws and rules to ensure adherence to these laws. And also, this is, I think, very important, our management team regularly audits and evaluates the work of our frontline staff. These documentations that the customers bring in are complicated, they're complex, and our staff, I truly believe, does a wonderful job following the process. And when there's a question, they contact our immigration attorney, send the forms to her, and she reviews them carefully and advises the staff. Furthermore, we are dedicated to the principle of continuous improvement. Effective February 1st of this year, BMV started providing free professional interpreter services to applicants for written exams. The applicant no longer brings their own interpreters. This new process requires applicants to identify what specific language services they need when taking the written test, the written basic knowledge test, to earn their Class C driver's permit on our newly modified exam application form. An interpreter will be provided to them at no cost. However, the BMV digital testing system also provides the basic knowledge test in 8 languages: Arabic, Canadian French, English, French, Portuguese, Somali, Spanish, and Swahili. If the applicant speaks one of these languages, they will be scheduled to take the test in our digital system at one of our 13 branch offices in that language. This will reduce the need for interpreters. If the applicant speaks a language our system does not provide, the BMV will provide a free interpreter for the written test. Scheduling that applicant and the interpreter may take 4 or more weeks to do. Additionally, should the legislature desire to designate authority to the BMV to hold applicants accountable for cheating, as I said earlier, we stand ready to work with the Transportation Committee next legislative session. We are confident that should your committee choose to open an investigation into BMV's licensing system, that we will pass those, we will provide that information, and it will be accurate and complete. We look forward to working with you and answering any of your additional questions.
Thank you very much for preparing very detailed answers to the questions that the committee compiled for you. There are questions just from the top. The free professional interpreter services are free to the applicant.
Yes.
What do they cost the state?
Between $60 and $70 an hour. Our plan is to group applicants that speak the same language together and hire an interpreter for, say, 1 hour with 5, 6, 7 applicants to make sure our resources are used appropriately.
Thank you. The chair recognizes Representative Perkins, followed by Representative Lemon.
Thank you, Mr. Chair. So I'd like to just go back to question number 6. So on the Secretary website on BMV, under documents required for limited legal presence, number 9, it says a notice to appear, court hearing, notice, or other evidence indicating a currently pending removal proceeding is an acceptable form of documentation. And that, if you look at rule number, chapter 15 of the rules, which are established by the Secretary of State, that's established by rule. Am I correct there?
Yes, you are.
Okay, that was my question. Is that established by rule or
Yes.
law? Your answer was it's established by rule and law. I want to know, was that established by rule? But that's established by rule. So it's the Secretary's decision then to allow a summons to court saying that we're going to deport you as a document that says you're here, you got a valid status to be here. Is that
What?
correct?
One of the reasons why that's on the list is we don't know at that time when they're scheduled what the outcome of that hearing is going to be. Because we're looking at the appointment notice, we don't know what the outcome will be.
Well, I understand we don't understand the outcome of a court hearing until after it's over. Don't you think it would be in the state's interest before we issue somebody a driver's permit or a license to wait until the outcome of that court hearing?
At that time,
In the interest of public safety, at least?
they have legal status and they are able to.
They have legal status because the secretary gives it to them. Right, thank
Do you
you.
want to?
Sir, 29A does not lay out a set of criteria. It just directs the secretary to determine legal presence. So the process that the department went through 4 years ago was to create a set of rules and run it through the appropriate public hearing and the rulemaking process to give our staff some guidelines. And this was.
Oh, yeah, I totally agree.
that process.
1301 doesn't give any
Yes,
guidance. And so that's rulemaking. But that's specifically up to the secretary to define what that criteria is. And one of that criteria is if we give you a ticket saying we're going to deport you, then that's good enough for us that we're going to allow you to operate on our roads. It's the fact that you are potentially an unlawful alien in the United States that I get that. That you basically just repeated what I said, but thank you.
I would also add that during the rulemaking process, there is opportunity for public comment. We followed that process very carefully, and we're adopting rules all the time, and public comment influences the outcome of the final rule.
The chair recognizes Representative Lemon.
Thank you, Senator, and thank you for being here again. I have a couple questions. One is in your attachments, it's crystal clear that in 2019 and 2020, the department knew that there was cheating going on from interpreters. If that's the case, why, when examiners that came forward to me as whistleblowers, why, when they came forward to you and said, I think there's cheating with interpreters, why wouldn't you automatically assume that it's happening again and investigate it and stop it?
We asked many times for specific situations where we could point to something, and as you see in these documents, it was always very vague, very much of a discussion, but never anything very specific. And one of the charts I would point out to you is on the second page of the investigation done by Bruce Hurley. And you'll see that there are three, at the bottom of the page, you're going to see that there were 3 interpreters that gave tests. This chart indicates that, so for the first interpreter gave 25 tests. 14 of those individuals passed on the initial test and 11 passed on the retest. That point here that there's a retest tells me that they weren't passing automatically at every single test. They had to take a retest, so there's indication that people failed.
But the conclusion of the investigator is that there was cheating.
The conclusion indicates that there was a concern. And I will tell you that we have been looking at it very carefully. We've been watching it. As a matter of fact, we last spring hired a new chief driver license examiner. He is a former state trooper, retired, and worked for the Federal Motor Carrier Safety Administration for a short time. Chris, Director Ireland, as his immediate supervisor, gave him priorities to work on. One of the priorities that he provided to him was, please review our interpreter services program and make any recommendations for program improvement. As we said earlier, we're always ready to make improvements to our program. The new chief examiner came back to us started his review in October, came back to us in January and said, here are our recommendations. Let's provide the interpreters ourselves. And then it puts all of this to rest. And we did that on February 1st. So it has been important to us. We've been keeping an eye on it. We didn't have anything concrete, but we feel that we have taken steps. If anything was happening, that we've taken steps to prevent fraud, which we do in everything we do. We're looking at our programs to see whether, are there opportunities for fraud? Let's try and find a way to close that.
Okay. My last question is, of the free professional interpreters, are you hiring any of the ones that these whistleblowers have brought forward saying that there's like 3 particular whistleblowers? I mean, you have 5 whistleblowers and they all name the same interpreters. Are you hiring any of those interpreters to work for you that are already accused of cheating?
We hired the same interpreters that the court system has hired. We have 3 interpreters. Chris, I think you have the list of, they have been vetted. They have a master agreement with the state procurement system. We're using those. We talked with the court system and have one individual there that manages their entire interpreter program. And these interpreters were highly recommended, and we modeled our program after theirs.
So is that no to his question, or are you not sure that there's any overlap?
Do you
between-
have the name of the list of the companies?
I think your question, sir, was about specific interpreters that were
Correct.
flagged by the examiners that have communicated with you.
Correct.
I don't know that we've been provided those names. I can tell you that the names identified in the reports under the previous administration are not interpreters that we see currently. And certainly can be looking for that if they've worked their way into one of these interpretation agencies that the state has agreements with contractually. But as of right now, with the program as of February 1st, we're using 1, 2, 3 organizations. And it does not include the organization that's currently being questioned under work with another department. So
Thanks.
So you could look into that? If I gave you the names, you could look into it?
if you gave me names, sir, we'd be happy to.
How would I get you those names?
I would say,
I'm not sure what your process is. Do you have an internal process for communicating?
The
with
reason
us?
I'm asking is, Mr. Ireland, I emailed you and asked you a question about whether or not on February 1st, you were going to stop using outside interpreters. You responded back to me in a very vague manner and didn't answer yes or no. And yet you already knew that the answer was yes. And then when I asked you earlier why that was, you said you were told that you are not allowed to respond back to the legislators. So my concern is if I emailed you and gave you the 3 names, you already told me that you can't answer me back. So how would I get a response?
I'll be happy to answer that. If you email any one of us, we always forward our emails to our leadership. We discuss them with our leadership. And a discussion was held regarding your email, and we believed it was appropriate for us to answer your email in front of the committee, so all committee members had the same answer at the same time. Whenever we receive a inquiry from any legislator, we speak with one voice at our department. So we make sure that we're all in line and we are all in agreement with how the response is provided, because we want you to have accurate information.
Right, but if we don't call you back, your answer says that if we don't call you back as a committee, you may not answer me. I may not get a response back from you because you want to give it to all of us at the same time.
Our leadership does an excellent job of ensuring that responses are given to legislators. And I really believe that you can count on that.
And thank you for that. And in this situation, we're in a process of deciding whether or not we are going to evaluate this further. And I think that this is no defense of an answer. It's just wise to not communicate with individual legislators about something that is already in front of the whole committee. And so to answer the question you asked, Deputy Secretary, we have all kinds of avenues through our director in the office to submit information to him, who can in turn talk to you about whether or not these 3 names are anyone that you are currently hiring. And I would suspect that whatever action we take today, that's kind of a simple thing to do, which could also inform whether or not the committee wants to move forward with anything other than just an open conversation with you at this point in time. With that, the chair recognizes Senator Dusan.
Thank you, Mr. Chair. Thank you, guys. Very detailed response to our questions. And I also have to throw a little shade over there to Mr. Schleck for how well he crafted the questions.
Good shade.
You mentioned continuous improvement in the
Mhm.
course of these activities, and I've experience in that process. I trained total quality management, trained others in total quality management. A part of that process, when you're engaged in trying to, you do your best, you see how you've done, you figure out gaps, and then you do your best again. It is a continuous cycle. It's called plan, do, check, act. So I am wondering if you wouldn't mind sharing with these changes that you've made in response to the set of concerns brought to your attention. Have you already developed a set of plans or concepts as to how you'll check on whether this is taking care of the problem and we just continue along that cycle?
We will be communicating with our staff often. I just asked Director Ireland yesterday, what kind of feedback are you getting from your staff? What are they, what are they saying? What are they seeing? Have there been any concerns, any problems brought forward? And so far there has not. We will check the data. We will keep an eye on the program to ensure that it's working the way that we want it to. We also have a reconciliation process that we use to ensure that we are being billed appropriately for the interpretive services. Our employees, every time that they're responsible for getting an interpreter, they fill out a form. It's sent to our accounting department. When the bill comes in, we verify the amount of time that our employees said the interpreter was engaged, and then that is reconciled with our bill. So we have several steps that will be taken. And Director Ireland, is there anything I missed?
Yeah, boss, Senator, one of the things the boss forgot is we put the plan together for her and the secretary to review for the 1 February changes. Was a commitment to look at the data and the results of, examination pass rates and a couple other data points quarterly, just to see, is there a change taking place? And if not, then you'd be able to stay mindful of what's going on. So that commitment to, auditing, for lack of a better term, to see if we're doing things properly and make sure that we're not negatively impacting the people of Maine along the way as well. So that's part of our process.
Senator, you may proceed.
Your auditing, use of the word, program audit process, you're auditing the changes, the impact of the changes. I hope that you're going to also talk to your customers. Some of what we heard in the presentation of the problem, there were implications that customers who might need these interpretation services might have experienced directed referrals to certain interpreters who were regularly in our system, familiar with our system, or they might have had access issues in terms of finding an interpreter to come to motor vehicles, just to engage in this government process of getting a license. I suspect that your new system might actually make interpretation services more accessible for people who might need them. And you might find some feedback on that by asking the customers who are impacted how the new system is working for them.
Appreciate those comments.
Chair recognizes Representative Ms. Strachio.
Thank you, Mr. Chair. I was looking at the investigations,
Yes.
and I guess it didn't take me long to figure out why this, whether it was right or not, but why this got missed. And I see the date from Robin Stankovitz, motor vehicle detective, March 19th, 2020. I mean, I think that is really, that date is when things shut down from COVID. And then at the end of that year, we had a new Secretary of State. And that was when things were just starting to figure out how are we going to run government and in a safe way. So I know I was here for the 129th when we were sent home and didn't finish our work. I know there was a lot of work left, and this clearly was something that might have been addressed, I would assume and hope that it would have been addressed in that time. And then coming back with a new Secretary of State. So my question is, what can you do in your department to make sure that things that are hanging there, I mean, I'm hoping this is a one in a lifetime event, but it looks like this was just like the perfect storm of how to forget something that's going on. And then when it came back to the fore, probably I would say when I know that there was like, in my community, at least, a large influx of asylum seekers, and maybe, I know that within our school system and in our other government offices, trying to figure out how we were going to use interpreter services for all the things that we were doing at the time. So I can see what happened and how can we avoid missing these kinds of issues in the future?
You're right. We had a lot of changeover in staff. At that time, we had a lot of retirements. People didn't want to come back to the building, come back to work after COVID. So we have had a lot of changeover. I think that we're committed to continually communicating with our teams. So if I were to leave or Chris was to leave, there is the continuity. Our staff below us know what we know. They would be there to continue that work that we're doing. I will tell you that right now we have over 80 projects that we're working on. We have a lot going on, all very positive, all trying to improve our customers' experience, improve our employees' experience. We are tracking them on spreadsheets and project management tools. We're also using now SharePoint so that there isn't something in my project list that nobody else knows about. We're sharing that among all of our team, many layers within our organization. So I think our communication and our inclusion of our staff is stronger than it's ever been. So I hope that we continue that and we'll keep that communication going so that when there's another change of administration, that knowledge is retained. Have I missed anything?
One of the things that we've taken on in the last year and a half has been a suite of tools to help us see ourselves through data. And admittedly, if you were to visit the Bureau, you'll walk away going, we're still cranking a lot of paper. And that's absolutely true. But as we continue that migration, that modernization to get out of paper, get data available, and then to be able to look at it and reference it, those are the kind of things that keep discussions alive, because you create dashboards, they're showing you what's happening, and it gives you a chance to follow up. And whether it's a project list like the boss is talking about or something else, those are the kind of modern management and leadership tools that start to bridge the gap that you're talking about. And no solution perfect, but that starts to get after it.
Thank you. The chair recognizes Representative Perkins.
Thank you, Mr. Chairman. Don't throw your water bottle at me, Deputy Secretary, but it's about question number 6. But it has nothing to do with summonses, I promise.
Okay.
So it just piqued my interest in the last part of the answer that you provided with us on this. It says you're adjusting the process on the legal presence determination based on this modernization of your digital licensing system. Can you just, for my sense of being in mind here, can you just give me a brief overview of how that's going to be adjusted, what that modernization process entails, and how we do licensing?
Yes.
Very quickly.
We are building a new computer system. And we're overhauling our driver license system. A lot of improvements with that. What we plan to do here is to move seeing the customer's documentation before we give them the permit. So our computer system is going to have to be changed so that process is in the front of the system instead of the middle of the system, I would say. Now, Chris has been leading that process, so I'm really going to let him add a little bit more color to that.
So, sir, I think what you're asking is this modernization project that we have underway, you're wanting a little more information on what is that? What are we doing?
Specifically, how it's gonna impact the documentation process. I mean, I'm sure there's a lot to this and I don't need all of it, but how it's gonna impact the documentation. But based on what the deputy secretary, logistically, how is that gonna affect like when a young person goes through driver's ed and they're immediately given, that little paper permit is it something that they're gonna have to now go to the BMV before and show documentation before they get that, or are they still gonna be able to get it right from? I mean, how is that gonna work?
So we think, so the reason we're not jumping on this now is, as the boss described it, we'd have to redo the computer code while we're trying to finish redoing the computer code. So this is, on the docket for July to start to really dig in and start to work those types of solutions. We think we have it envisioned in such a way that we can do this without imposing an extra visit on the customer to come into the bureau, wait in line, get an appointment, et cetera, et cetera. So it's moving the data gathering and some of these other steps to the front side, middle of the process. So and then they're not having to come back in at the end. Because right now you complete your road test. Congratulations, you're licensed, but to get your piece of plastic, you have to come in separately another day. And we think there's a way to migrate that without imposing extra burden.
So just to
on the
get the
customer.
permit before the license, they would still then all this documentation, the I-551s or whatever, they would have to provide all of that ahead of time now.
Or a birth certificate if you're a US citizen.
Right, or
Yes, sir.
whatever,
That's
yeah.
right. Yeah, so
Okay.
I just totally lost my train of thought.
It's
Now,
okay,
would
we'll
that
come
affect
back.
real IDs too?
A real ID is it's an enhancement or a
Right, that's what I'm
modification of
saying.
an existing state credential, whether that's ID or license. So that's, if you declare to us at the time you initially apply that I want my first driver license to also be a real ID, we would be working that with you from the get-go.
Okay.
The thought that I had lost there for a moment was, goodness, I just lost it.
I think I get the gist of it. I think you've
Yeah.
answered me sufficiently.
If it
but-
comes back, you can
Yeah.
interrupt
Oh,
at
yeah.
any time, sir.
I apologize,
Okay,
goodness.
Director.
No, that's all right,
We
George.
all
I
do.
really appreciate that. Thank you.
Yes, sir.
Chair recognizes Representative Lee.
I'm gonna swerve a completely different direction, so you will not remember that. I wanted to thank you for your answers, in the writing as well as for the remedies. It's nice to actually have some remedies for a recognized problem, as suggested. It seems like what went into effect February 1st is precisely the way to deal with the problem that's been isolated. I did want to stress though, this was a real problem. And I had a slightly different reading of the Hurley investigation than you did.
Okay.
What I understood was those retests were also discrete actions in which the interpreter was involved when they may not have been involved in the initial test. And so those three interpreters seem to actually have a legitimate 100% passage rate.
Wasn't 100, it wasn't clear to me completely in that. I wish we'd had stronger
Yep.
data. I wish he had explained this more. I took something different from it than you did,
Yep.
but I totally see how you got there.
And I think Representative Mastracchio did a pretty good job of outlining the why this sort of sat on the table, but it did sit on the table. And I'm wondering, you've talked about potential legislation for the 133rd, and would part of that legislation, I don't know, give you more authority to isolate these things when you see them in existence with an interpreter in the future?
I think we will have, we are looking at how could we have authority to deal with it? Some of our colleagues in other states will require a certain length of time before an individual can be retested. So there are models out there that we're going to be looking at in other states. I forgot your first part of your question.
So what I'm kind of thinking is it would have been nice in 2019 if after this person, the line person seemed to have made a correct observation when they made this complaint, and the investigator seems to have not concluded that they had a prosecutable case against these individuals, but concluded that there's something not right going on with these three interpreters. And I guess I'm just wondering, rather than it's sort of sitting there understandably for several years, if what you're seeking is a way that action can be taken against those interpreters more effectively from the jump.
Yeah, I think, sir, by and large, the answer to your question is yes. And we think what that conversation might sound like would be a delegation of administrative authority to the secretary, such that we don't have to continue to pursue criminal standards and bog the court system down and bog down formal law enforcement investigations down, that then would allow someone at the deputy's level or my level or somewhere under the secretary's purview to look into and then put an offending applicant or interpreter into some form of in some form of penalty loop or something, right? But right now, the only tool we have available, as Representative Lemelin pointed out previously, is that there are statutes related to fraud, but they are about misstatements of facts on documents. And beyond that, I don't have the ability to do much about it.
I think that's absolutely right. And I think that's the right approach. And as I said, the reason I think I appreciate the remedies so much is because it almost takes away any necessity for you to have to do that in the future or for these reports to happen. So I appreciate it.
Thank you. Are you anticipating that the legislation that you would seek to give you such authority would be something that the department would present? Or are you suggesting that the remedies that you have outlined and the authority that you would request would simply come from a legislator themselves?
I think that's a conversation that probably the Secretary of State will have with the chairs of the Transportation Committee, and we will develop a plan with their input.
Thank you. Chair recognizes Senator Dusan.
I was going to hold off on this until we had a discussion about what specific additional authority you might be interested in. One caution that occurs to me that I made a note of is, as I said, this could actually be a great improvement for people who need or request interpreting services. I would have concerns if this system wound up completely at the other extreme, such that I, as an individual who speaks another language, may not bring my own interpreter. I'd be fine, if the departments or the government interpreter needs to be present at the same time, if there's any hint of concern. But if I've done nothing that is suspicious and I am about to take the exam and request to have my interpretation done by my adult child, I don't know who to put in that blank, but I wouldn't want there to be an automatic bar on you being able to select your own interpreter, particularly given where there's no situation where there's a concern. So I would say, particularly where there's no situation where there's a concern. For example, if I spoke Russian and I were wanting to bring my interpreter and there wasn't a Russian interpreter in the digital testing system, and the Bureau did not have a Russian interpreter available, could I not bring my own interpreter?
As of February 1st, we're providing all of the interpreters.
Does that mean that a examinee is barred from bringing their own interpreter?
There are always unique circumstances that we would look on a case-by-case situation, but the normal process will be that the individual will let us know what language they speak. The first step will be for them to take the test in their current language if we provide it. If we don't provide it, then we will provide the interpreter for them. If there's some type of situation that is unique, we always look at unique situations on a case-by-case situation.
If I may just press one half an inch further, in terms of trust on both sides of the system. I understand the department making the resource available, and I think that's laudable and probably required by law. But if I want to, can I have a third party in the room? If I am not certain that if I have any qualms about the veracity and skills of who the Bureau has selected to interpret for me, I might request to have someone who speaks my language present. That doesn't mean that the exclusion of the department's interpreter, but someone whom I trust, who understands my language, can interpret for me. It's maybe even interpreting the interpreter. I just, it's a leap to, yeah.
As
You understand what I'm asking.
I
So
do.
I would just ask that as we develop the system, that we proceed with caution around that narrow issue.
You made a great point earlier when you said that we should get our customer feedback as we're proceeding. And that was a great suggestion. I think those kind of concerns would come out as we do these evaluations. So thank you for that. And it's a great point.
Chair recognizes Representative Lemlin.
Thank you, Senator. I'm very glad that you changed your policy as of February 1st and stopped using outside interpreters. I respect and understand the senator's remarks of using the interpreter of her choice, but in my opinion, I don't think it would really matter as long as the person speaks fluently in that language. But my only concern here is two things. One, that none of the interpreters are anybody who's already been accused of possible impropriety. And number two, that if an examiner comes forward, I believe, like when you get a phone call, like the person they're looking for in Arizona, no matter what the tip is, they've learned that they have to investigate it. I would just prefer that to happen here, that you trust your examiners, and especially when a person like John he's a retired police officer. So to me, that was the glitch I had, is he was trained in observing fraud, and yet nobody investigated what he was determining. So all I ask in the future is those two things. And that if your examiner comes forward and says there's a complaint, just look into it. It doesn't take long to just do a preliminary look-see. And those are the only two things that I'm concerned about at this time, and I hope are addressed.
Thank you, Representative. Chair recognizes
Thank
Senator
you.
Timberlake.
I really appreciate you guys coming back and answering questions. I'm still a little baffled. I've been sitting here listening. And I look at, in my own opinion, that in 2019, we had 3 translators that had 100% pass rate. And I just wonder how the department, or how somebody didn't say, geez, that don't seem right. What's going on, and how was that? I guess I don't want to say drop the ball, but I'd like to say, how was that missed, and how are we addressing that into the future to make sure that doesn't happen again? Because 100% passage is, and even to your own numbers, it's only 70 and 72. So how did we end up there and nobody ever caught it? I guess that's a part that baffles me, I think.
I had personal conversations with the examiners myself. I tried to get very specific information. A lot of the responses were, I'm guessing, it looked like they're all doing it. I couldn't react on those types of responses. we needed something more definitive. There were 2 investigations, those particular interpreters, they changed, there were changes in the interpreters. So it was very difficult to, be able to get exact information and, very specific conversations. How do you know that they were cheating? And the answer was, well, there's 15 words in that sentence. I'm paraphrasing. There are 15 words in that sentence and the interpreter only said 4 words. Well, that's hard to accuse somebody of something. But I take your point. I take your point.
I guess that's water over the dam, as we say. It's spilled and it's gone downstream. I guess my question is, we know that. What are we doing today to make sure that that doesn't ever happen again? I mean, other than we supposedly hiring our own interpreters and we're doing that, but there's not, it's concerning to me. I won't lie to you, but I'm not trying to, I'm trying to get to the bottom and understand it because it's been a problem.
There won't be a relationship between the interpreter and the person taking the test the way there is today. The model today, the person taking the test finds the interpreter, they have some type of relationship agreement and they help. With us providing that interpreter, they won't know who the interpreter is going to be beforehand. So when they walk into the room to take the test, there's going to be an interpreter that we've assigned. They're not going to know who that is. So there is the absence of that established relationship between the 2.
Thank you.
And thank you, Senator Timberlake. Thank you, Deputy Secretary. I don't want to undercount what Representative Mastracchio put into the record earlier about the timing of these 2 investigations. We can call it an excuse or an explanation or both, but I do think that the timing may have had something to do with it. And the agency has certainly responded. Now that they know that there's an issue that has been brought forward by the good representative. Are there any other questions for the director or the deputy secretary? I really thank you. I will express bias and say that you did a great job, both of you, not just because you're my constituents, but because I have the constituents that are just brilliant all over my district, and more will be in front of us today. In fact, I'm lucky that way. All of them, right? It does seem that way, doesn't it? But thank you very much for your preparation, attention to detail, and answering our questions clearly and concisely. And the committee will just take a moment to discuss what we may or may not do next. But we appreciate you being here. And if we have any other follow-ups, I think there might be 1 or 2, we will get that to you as well.
Great.
So
Thank you very much for your time. We really appreciate
thank
it.
you.
Thank you.
So we have heard now, our questions have been answered. And my question for the committee is, what is the will of the committee regarding this situation and whether or not we believe or don't believe that we need to direct OPEGA to do anything other than what we have done ourselves in this open forum? Chair recognizes Representative Mastracchio.
Thank you, Mr. Chair. So I'm satisfied with answering the question that was brought before us. What I think I think there are some issues that we could deal with, particularly the issue about what happens when they have a cheating issue, that we could send something to. I think that is the purview of the Transportation Committee. And I would like to suggest that we at some point I think we should write to them and let them know what we did and what happened and what we found, and then let them take it from there. That would be my thought process.
Thank you, Representative. Any other thoughts from the committee on next steps for us? Representative Lemon, I'm putting you on the spot. I know how passionate you are about this, and a problem has been identified. So what do you believe the committee should do other than or in addition to sending a letter to the Transportation Committee outlining our discussions and what we found and making a recommendation about how they might want to proceed?
Thank you, Senator. I am partially happy. Do I believe that we should vote for Mr. Schleck to do a deep dive investigation? No. Am I 100% satisfied? No, but I think enough has been done for me to back off. I hate that term, but you get it. Like I stated previously, the February 1st is a huge move. And I'm hoping that the department will consider my suggestions of keeping the people who have been accused of cheating off the list. And I hope they also consider my request that if an examiner comes forward and says there's further cheating, that they will look into it. Aside from that, I'm fine with just doing the letter to transportation as you have said, everybody has suggested. So thank you for allowing me to express that.
Thank you, Representative. Chair recognizes Senator Garin, followed by Representative Perkins. Senator Garin is with us online.
Not right now.
Maybe.
I
There you
would
go.
just, I would just like to agree with my colleague who just spoke and say, I'm not 100% happy with it, but I do think that the whistleblowers have come forward and brought a problem to us, and the problem has been acknowledged, and a solution and some steps going forward with the Transportation Committee. I think those two things combined would lead me to a place where I would say we could let this go for now, but certainly want to keep an eye on it.
Thank you, Senator. Chair recognizes Representative Perkins.
Thank you, Mr. Chair. I've said it before, is I don't think it's our job to go after people, but find solutions and to trust that we can and come to a place where we can trust those solutions. And while obviously I'm not happy with summonses being used as a status for getting an operator's permit, I think that the department did a good thing with changing the way they're using interpreters. But my question is, because we have to trust the solution, and I'm not in any way implying that we would trust their actions going forward, but as just a matter of integrity checking or monitoring or however you want to put it, would it be improper for us to ask them to come back in 6 months or a year and give us a comparison of pass fail rates on the test with those that use their internal interpreters and those that don't, so we can see that they're consistent, and then we know that there is no longer a problem?
I don't think that that is an unwise path forward as well. Follow-up is always important to see if a process has been improved. So I have no objection to that. Chair recognizes Senator Millett.
Well, Representative Perkins took most of my thunder with that one. But I would agree with everybody else. I'm not happy with what was happening, but I think it's been addressed. And I think they're aware that people will be watching, and I think that in the future, the department will pay closer attention to what's happening when they get a complaint. I mean, we all have learning curves, and sometimes we got to go through them. And so I'm happy with where we're at.
Thank you, Senator. Any other thoughts from the committee? Chair recognizes Senator Dusan.
I think at some point thank you, Mr. Chair. At some point I've said that a complaint is a gift, particularly a complaint to government is a gift. It's a gift from the complainant because in my mind, having worked through some of these processes, it is a notation that they think government cares enough to do something about what they're complaining about.
Mm.
And I think that that is the level of concern about our systems that is evidenced by the whistleblowers staying involved and pressing their complaint until they get an answer. I think a complaint is a gift because it's a gift to the system to look outside of itself, get that feedback so that you can then weave it into however you're proceeding. And I think that the Bureau has done that in this instance, maybe too late, maybe too slow. But what they're proposing as a systems adjustment makes sense to me. And I'm very happy to hear from my colleagues that what they're proposing as a system adjustment makes sense to you all. And lastly, I would say that it provides an opportunity for our oversight role to be able to focus that oversight, to be able to have these conversations as to whether we need to look further or in what ways we need to ask for report back information to see if the system is functioning the way it should.
Thank you, Senator. Chair recognizes Representative Perkins.
Thank you, Mr. Chair. Having heard all of this, I'd like to make a motion if I may.
You may.
I'd like to make a motion that we ask the Bureau of Motor Vehicles to come back to us in 6 months with a report showing us the pass rate and fail rates of all the people that take a test, both with and without interpreter services, so that we can compare them and see the effectiveness of their changes.
Thank you, Representative. Would you like to include in that motion that we
And the
send
letter.
a letter? to
Yes,
the
I'm sorry, Mr.
Transportation
Chair. Thank you.
Committee summarizing these concerns as well?
Yes, thank you.
There is a motion. Is there a
Yep.
second?
I will second that.
The chair has recognized Representative Stover with a second. Is there any discussion of the motion by the committee? Committee ready for the question? All those in favor of the motion, please indicate in usual manner. And I think Senator Garin. That's fine. It is unanimous of those present and voting.
There you go. There's my hand.
Can't vote on it.
No, she can't. Yeah, she can't vote on a procedural. So we have a full agenda and there are commissioners in the room and I do not want to keep them waiting. So what I'm going to ask of the committee to do is we'll break for another 5 minutes and not a legislative 5 minutes.
Real
but an
5 minutes.
Actual 5 minutes, and we'll just have to have a late lunch because I don't want to keep the commissioners waiting. They are here. So 5 minutes is all we get, and then we'll get right back to work. Senator Dusan.
So I would just ask Mr. Chair respectfully.
The committee will be in order. Welcome back to the Joint Legislative Committee on Government Oversight. Next, we return to the request, the request by Senators Timberlake, Farron, and Garrett, first discussed at our January 23rd, 2026 meeting. As we discussed then, there are a number of items in the letter that we have been considering in turn. One of which was concerning 16 non-competitive contract awards flagged in the most recent single audit by our state auditor, and another, some questions about the effectiveness of program integrity in relation to detecting potential fraud and other forms of possible non-compliance with state or federal requirements for Maine Care funding. We begin with Commissioner Clark of the Department of Administrative and Financial Services. Welcome, Commissioner. And again, congratulations on your recent confirmation to this office.
Thank you very much.
You are welcome to make a statement, including about the 16 contracts previously referenced. In that regard, I understand you were provided a copy of the letter from some of our Senate colleagues touching on this topic. And after your presentation, which you've informed us you have very well put together, the committee may have questions for you. So please introduce yourself and begin as you will. Turn the mic on. Thank you.
Thank you very much, Senator Hickman, Representative Mastracchio. I'm Elaine Clark, Commissioner of the Department of Administrative and Financial Services. You asked me to attend today's meeting to answer some questions about the state auditor's 2024 findings and about procurement justification forms that become notices of intent or NOIs when approved and posted. The letter that precipitated your invitation makes some disturbing allegations, and because of that, I appreciate being invited to this meeting today to have the opportunity to address them. Saying that procurement practices of the state of Maine involving the award of sole source contracts are already beyond suspect is unfair and very demoralizing to the professional staff at OSPS, some of whom I've been working with for more than 20 years. It was jarring to read the allegation that fraud has corroded the foundation of and now permeated Maine's entire executive branch. It is my intent to refute these statements. First, a few facts. Procurement Services, which has the acronym OSPS, Office of State Procurement Services, I'll probably use the acronym quite a bit, processes more than $2.1 billion in state procurements. It reviews close to 11,000 contracts per year, including renewals, extensions, and amendments. However, the total number of procurement contracts that were reviewed by the state auditor in 2024 was 45, and they did not have a value of 2.1 billion. They had a value of 7.3 million. And a full 5 million of that is one blanket financial assistance contract from DACF to farmers who lost income due to PFAS contamination. So it was a reimbursement program to the producers that met the criteria of that PFAS program. It was not a public procurement, rather it was a financial assistance grant program, and accordingly was not characterized correctly in the audit finding, which DAFS had pointed out to the state auditor. So when you back out the $5 million grant out of the 7.3 million that we're actually talking about, this leaves about 2.3 million for discussion, which is just over 0.1% of the total processed by the Office of State Procurement Services. The number of NOIs approved has declined substantially by about 45% from 2016 to 2025. From 2016 to 2019, they're averaged around 2,100 NOIs. And that was even after the PJF form was streamlined. Between 2021 and 2025, the average was around 1,100 PJFs. So we went from 2,035 in 2016 to 1,134 in 1,134 in 2025. That's a substantial reduction. So the purpose of the audit, the executive branch supports independent audits. The purpose of the 2024 audit was an independent review of the state's compliance with federal program requirements. The audit report, which is sent to our federal counterparts in DC, is the first step in the formal findings reporting process. None of this is finalized until the federal government has done its evaluation, and we have not yet received its evaluation of the state auditor's 2024 findings regarding the Office of State Procurement Services. I want to just say that the annual audit process is complex, comprehensive, and detailed work. The Office of the State Controller coordinates the administration's audit response process. The administration takes each audit finding seriously and has systems in place to ensure that findings are properly addressed and corrected. The administration responds to each finding in agreement or disagreement with pertinent information to support the administration's position. OSC performs comprehensive reviews to ensure that responses to findings are accurate, fairly stated, and well-reasoned. The controller agreed with OSPS in its responses to the 2024 audit, as discussed below. It is also critical to know that despite the various disputes between procurement and the state auditor, the bottom line is that the 24 audit did not indicate any evidence of wrongdoing, fraud, waste, or abuse. The auditor did not refer anything to the Office of the Attorney General or Office of State Controller for follow-up, as they would have done pursuant to Title V, Sections 200-C and 1541 for fraud, waste, and abuse. So there were 8 findings. I'm going to go through the 8 findings pretty quickly, and then the 16 NOIs that were discussed in the letter. The first one is claims that of the 23 federal contracts included in the sample, 5 did not contain required federal award information. Well, the state auditor has a central review of federal programs. The FY24 audit finished with, quote, no findings noted during testing. Another way of saying this is the federal programs audit for the same time period by the state auditor yielded no findings for OSPS. That's on the federal side. While contracts are not considered, the second audit finding was that a majority of contracts and PJFs tested were signed after the start of the contract. And specifically that 18 of 31 PJFs tested were signed after the contract start date. The response that we submitted, and it is the way things actually work, is that the dates on a PJF are clearly labeled as proposed dates. They're for internal review and workload management, and they're not determinative of final timelines. Only the contract is determinative of the final timeline. So those are proposed dates that were misinterpreted by the auditor. The third finding was that 16 of 31 PJFs tested were designated as sole source and there was no documentation. After I finish all 8 of these findings, I'm going to go through each of those PJFs so you'll understand in detail why this finding should have been eliminated. One contract was encumbered and approved as a sole source contract prior to work being completed. This is the one finding where the Office of State Procurement Services and the controller agreed with the auditor. In one case, an invoice was generated prior to the start of the contract. Corrective action was taken. Procurement Services reviewed relevant procedures with staff to ensure compliance in the future. Next, number 5, document to support performance of a cost analysis as required by state policy could not be provided for any of the 45 procurement actions tested. In this one, the auditor was looking at a 2015 manual from the time when some of the materials were handled by a position that no longer exists. And it was when the system was paper-based. The procedure was no longer relevant. It was from a 2015 manual, and thus the finding had no relevance. The next and 6th finding was that 7 low-cost service contracts were tested. And the idea of this is that agencies are not supposed to stack contracts. So in order to avoid like a $10,000 limit, they'll do multiple smaller contracts to get there. Those usually get caught. So of the 7 low cost service contracts, 4 were to vendors already engaged in more than one low cost service contract within the same 12-month period. The reference to low cost service contracts is only partially accurate. Agencies can have multiple agreements with the same vendor under certain conditions. Stacking avoids proper procurement processes. The procurement office reviews relevant documents when stacking is suspected. And under this finding, 2 of those contracts were reviewed to indicate possible stacking. So there was partial agreement with this finding. It was possible that 2 of the contracts were stacked. So that's a partial agreement. The 7th, the OSPS did not request or review information related to vendor performance during the contract amendment process. OSPS does not sign contracts or oversee vendor performance. These responsibilities lie with agencies. Number 8, of the 8 IT-related contracts tested, 2 were approved through procurement services without documentation of OIT review. Again, there was partial agreement with this one. One IT-related contract was not reviewed by Maine IT in advance as required. However, the other one was properly handled. So what this is telling us is that 2 of 11,000 contracts were not perfect and needed some attention. OSPS agreed that both of those contracts should have been handled slightly differently.
The chair recognizes Senator Tipping.
So very sorry to interrupt and really appreciate you going through all this. I'm having a little trouble following just one after another here. I wonder, is there a written or electronic version of your response that we could be reviewing as we're hearing from you?
I'm sorry, I did not bring the written testimony, but I told the chairs that I would submit it following the hearing, following the meeting. I wasn't sure if you were going to let me use written comments, so, because it was framed as a question and answer, so I will provide those as soon as I leave here.
Okay, thank you.
So you'll have a chance to look it over. The 16 notices of intent that were, sole source contracts. There are 7 types of waivers of competitive procurement in statute, including when the governor or governor's designee deems that an emergency exists, or when a specific item or service is available from only one source, or when the goods or services cost less than $25,000. Many of the 16 contracts that were questioned, excuse me, were exempt from PJFs and procurement, as they were existing contracts that simply rolled into a new fiscal year, and others were legitimate sole sources. So I'm going to go through categorizing the 16. 7 were multi-year contracts that rolled into new fiscal years. New PJFs were not required. 1 was listed as a single source in error. The contract had been competitively bid, with awards made following the RFP process. 1 was a fiscal year 2024 PJF to provide funding to all of the 8 district attorney offices for victim advocacy services as funded under the VOCA program. They all received the same amount of money. This was reviewed and found acceptable by OSPS. 1 was for a contract language change related to a new schedule due to unavoidable delays in 2 areas. The amendment merely changed the work plan and was accepted and approved by the federal CDC. 1 was for a single source vendor who had demonstrated unique qualifications for marine geotechnical work to design marine retaining walls for boating facilities. 1 was an amendment to add 2 additional trainings to a 2-year-old contract. 1 was a contract pursuant to an approved MJRP business case. The grant award was made to specific workforce boards who then distributed grant funds pursuant to an approved business case. 1 was a language change and a no-cost date extension. 1 was an amendment to remove LLC from a provider's name for a contract directed to a provider by a Maine court. 1 was a fiscal year 2024 contract submitted under a willing and qualified classification. The contract was for appraisal services for a unique area where there is very limited pool of appraisers that are qualified to assess potentially conserved forest lands and who can perform appraisals that meet the requirements of federal funding sources. Willing and qualified is a designation. It's used when there is an insufficient number of providers to meet program needs. It is based on a federal model set out in the Code of Federal Regulations. These PJFs are posted on the OSPS website for the life of the contract to encourage additional vendors to get on the list of providers. So in conclusion, procurement services, with the support of the Office of State Controller, refuted 7 of 8
state audit findings in writing. However, no changes were made to the disputed findings by the auditor despite explanatory information. The 16 audit findings criticizing NOIs were largely incorrect. As you can see, most of the contracts or amendments or were year-end rollovers, were not subject to competitive procurement. I hope this has been helpful and clarified that OSPS is a hardworking unit with major responsibilities that each and every employee takes seriously, using professional standards and judgment. It is unfortunate that through a series of misinterpretations, the letter dated January 8th, 2026 was submitted to this committee. I would also like to add that there was something in the letter about not responding to Senator Harrington's letter, and that response was in process at the time and was sent out on February 9th.
Thank you. And will you also have a copy of that response
Yes, I will
for
do
the
that.
committee? That would be great. It may be difficult for questions without being able to follow along. However, I was listening and others were. So if there are any questions from the committee at this time, Chair recognizes Representative Senator Timberlake.
I thank you, Mr. Chair, and I thank you for being here this afternoon. And I'm sorry that you find the letter offensive, questioning, but I don't. You know, that got there in some portion, I would say, Director, by, Commissioner Matt Dunlap came in his department and gave us the thing. And are you saying that they're incompetent? That what the stuff that they brought through is not true? Because that's part of what got us to where we're at. We're also getting stuff every day from the federal government claiming things. So there's a lot of concerns we got going on, and we just need to verify them. And you went through that and read me stuff that I can't remember it all. I would have thought that we'd have got that in a written form so that we could have followed along and I could have checked and highlighted things. So, Mr. Chairman, I'm at a point that I think that we need to have that information given to us and come back and review it and be able to analyze it, because she fed so much information so fast that unless somebody here is, which everybody here is smarter than I am, I'm sure, but could possibly keep up with what was being said and what was being said, because I do have some real concerns over what was said.
Thank you, Senator Timberlake. Any other thoughts or questions? Chair recognizes Representative Lee.
There seems to be a quite, from what you said, quite a broad gulf between your understanding of the materials and the auditor's understanding the materials. And I'm just trying to, how frequent or common is that? And do you have an understanding why they made no corrections to the audit based on your observations?
All I know is that our responses were submitted in cooperation with the Office of State Controller, who endorsed and believed in our responses. And I don't have enough of a history with audits to know whether it's a common practice for responses to not be responded to, because we did not get a response. So I'm unable to answer that part of the question.
Chair recognizes Representative Stover.
Thank you, Commissioner. So Commissioner, I took a lot of notes and I've read the documents. I'll be excited to see yours because I bet it's a lot more comprehensive than my scribbly notes. But what you highlighted in the beginning, there were no findings of waste, fraud, and abuse. And then the findings you did share were, and these are my words, they're not the state auditors, they're not yours, they're my words, are explanations of findings. So it is not, in your opinion, you're very experienced, in your opinion, is it common that, whether it's a state or federal audit, that there are findings and then the agency being audited has an opportunity to respond to the findings? And I'll use an example. This is I'm just pulling an example. You didn't say it. I'm just using it. So I work for an XYZ agency and it's a mental health provider and it has a quality assurance department. And I'm a case manager and I forget to sign off on a bunch of notes or treatment plans in my documents. That's really the quality assurance department. It's supposed to double check my work and make sure all my things are checked off, and they don't. So there's a finding. in that audit that, that could put some of the funding to that agency in jeopardy. I'm just saying hypothetically. But once the finding of fact is there and my agency would be able to provide the information, oh yes, the treatment plan was done. It's just that the caseworker failed to provide the date and the signature. That was the finding. I guess what I'm trying to say is there can be no findings of waste, fraud, and abuse, and there can be errors found in the audit that then are explained. That's what I understood you to give us for the PGFs and for 2 out of 11,000 contracts. Those are explanations of a finding and then this is what happened, right? Is that common in your practice?
Very common. Yes, and when we're incorrect or when we made a mistake, as I told you today, we admit it. There were 2 contracts where there were flaws and we admitted it and corrected things.
Can I have a follow-up, Mr.?
But you may, I want to just remind the committee, in case we forgot
Yes.
about our own work, is that at our last meeting, we voted to task OPEGA with a review of these particular contracts that the commissioner has made reference to. And I wanted to remind the committee of that and wonder if there was anything we needed to change about that in light of what the commissioner has shared with us today. Representative Stover, you may proceed.
So you would have had an opportunity to provide, upon receiving that, a response. That's what you do.
And we did.
Thank you.
Any other thoughts from the committee? Chair recognizes Representative Lee.
As to those 2 contracts, you said you corrected them. Were there recommendations that came with these findings? The auditor?
Let's see, on the IT contract, there was a recommendation to, in the future, get pre-approval for the IT contract that was missed. So that became a correction that OSPS made and trained their staff on so that it wouldn't be repeated. Same with the other contract. The other contract was somebody mistakenly let an invoice be paid and approved before the contract was signed. That was pretty bad. That was a mistake that somebody made and corrective action was taken. The leadership reviewed the procedures with staff to ensure compliance in the future. That was corrected immediately.
Thank you. Any other questions? Chair recognizes Senator Timberlake.
And this is more directed at you, Mr. Chair. I guess, as I had to go back and reread my letter, because I had sometimes have to. So I'm asking you, what are we tasked here with today? Because, in my letter, we ask about Gateway and some other things, and I don't hear anything about that or anything else. So I don't know where we're at, and I'd just like to be told where we're at and what we're supposed to do.
Where we are at is that we have tasked OPEGA with a review of these 16 contracts. And I believe in the motion, if I recall, it's in our summary. That was the starting point, but we were not going to restrict OPEGA from looking at anything else that they might find in the process. So this was a preliminary discussion with the commissioner about these sole source contracts that were in the audit report. And I don't think I've heard anything that would make me say we should take a different approach. I do believe that OPEGA should continue forward.
And I'm just trying, and I'm thanking you because I didn't know exactly where we headed because I don't know where to go with my questioning at this point. So as I understand it, we started, OPEGA's going to do their review and then report back to us
That is correct.
about what they start to find. And then we can either expand it or not expand it as we see fit.
That is correct, Senator Timberlake.
Thank you very much. I now understand it.
Thank you. Any other thoughts or questions? Chair recognizes Senator Dusan.
Just to be sure of my understanding of the way in which these reviews are integrated, the audit findings.
The bonded, did you say? Sorry.
Audit
Yes.
are kind of part of the roadmap for the OPEGA review. Provides a course of a set of sample cases to follow up on, and Mr. Schleck and his excellent experience may, in the course of following that trail, look at other things, but essentially it is integrated and tied together so that the inquiry or responses that we get back can all be tied together, and we can assess whether we're getting a response to the questions raised in the letter.
Correct.
Okay.
Thank you, Senator Dusan. If there are no other direct questions for Commissioner Clark, we appreciate you being here at our invitation. We look forward to you submitting in writing what you have read into the record.
Will do.
And we look forward to what our able staff brings back to us for review whenever that is ready.
Thank you very much.
You're more than welcome. And again, congratulations. We now welcome Commissioner Gagney Holmes from the Department of Health and Human Services, who is here to discuss with us her department's efforts to ensure program integrity in Maine Care. I know that she has brought people with her, and I will allow you to introduce yourself and those that you have brought in turn to take our questions after you present, however you would like to present, based upon the letter that you also have in your possession. Good afternoon.
Good afternoon. Good afternoon, Senator Hickman, Representative Mastracchio, and members of the Government Oversight Committee. I am Sarah Gagne Holmes, the Commissioner of the Maine Department of Health and Human Services. Thank you for the invitation to appear before you today to share information and insight on the department's longstanding, multifaceted approach to oversight and accountability of taxpayer funds. We are here today because DHHS takes its duty to safeguard public resources seriously. I am joined by the department's 3 deputy commissioners, along with our subject matter experts. I want to begin by underscoring the importance that the department places on program compliance and integrity. This morning, this afternoon, you will hear from 3 units within the department that play a central role in identifying and responding to non-compliance issues that may rise to the level of a credible allegation of fraud, and that serve as our primary mechanisms for oversight and internal control. In addition, every office that works with Maine Care providers has a process to take corrective action when program or contract requirements are violated, to refer concerns to the Maine Care Program Integrity Unit, and to meet regularly with the program integrity staff to ensure information is shared between offices regarding noncompliance. This enables the following units to have awareness on issues across the department. The DHHS Division of Audit, which sits in the Commissioner's office and supports the entire department, manages compliance reviews and expenditures across contracts and Maine Care, including cost-settled payments. The Fraud Investigation and Recovery Unit within the Office for Family Independence, which investigates and acts primarily on allegations and instances of fraud by recipients of benefits. And the Maine Care Program Integrity Unit within the Office of Maine Care Services, which manages surveillance, review, and when appropriate, referrals to the Healthcare Crimes Unit at the Office of the Attorney General, the state's Medicaid Fraud Control Unit, which happens when program reviews identify noncompliance that meets the legal threshold of a credible allegation of fraud. It is our hope that the committee finds today's presentation helpful in illustrating the processes DHHS staff follow to identify and address fraud, noncompliance, overpayments, and when appropriate, to refer matters to the Office of the Attorney General or appropriate law enforcement agencies. Delivering today's presentations are Todd Haber, who is sitting next to me, Acting Deputy Commissioner of Finance, who will provide a brief overview of the Division of Audit. Tom Roth is here. He's the Director of the Fraud Investigation and Recovery Unit within the Office for Family Independence, and Bill Logan, who oversees the Program Integrity Unit within the Office of Maine Care Services. The presentation you will hear today is the same presentation that we provided to the Health and Human Services Committee several weeks ago, and that was specifically the request that we had to provide that information to you today. Before we begin, I would like to offer a brief overview of the department's approach and why this work is so important. The Maine Department of Health and Human Services provides essential health and social services to Maine residents while safeguarding the public resources entrusted to our care. Every dollar we manage represents a commitment to ensure funds are used lawfully, effectively, and in direct support of the programs and people they are intended to serve. Given recent public interest in the handling of fraud allegations within publicly funded programs, including high-profile matters reported in other states, the heightened national scrutiny makes public understanding about the department's legal authority and established procedures essential. Maine DHHS operates under a framework of continuous audit, claims review, and compliance monitoring grounded in state and federal law. These processes are designed to identify billing errors, detect noncompliance, address documentation gaps, and ensure public funds are used appropriately. When issues are identified, the department acts through mandatory corrective action plans and recovery of overpayments. When concerns meet the legal standard of a credible allegation of fraud, the department, as required by law, refers those matters to the Office of the Attorney General or appropriate law enforcement agencies. This division of responsibility is intentional. DHHS administers programs, provides oversight, and conducts audits to ensure compliance. Law enforcement investigates potential criminal wrongdoing. That separation protects taxpayers, preserves the integrity of investigations, and safeguards due process. State and federal law also require the department to take specific actions when a credible allegation of fraud is identified. Under federal regulation, Maine law, and the Maine Care rules, the department must impose a payment suspension unless good cause criteria are met to delay that action. Those exceptions are narrow and purposeful, such as when law enforcement requests a delay to avoid compromising an active investigation, or when immediate action would jeopardize access to critical patient services. Taken together, this means that the department works in this area is not driven by discretion, public opinion, or informal judgment. It is dictated by law, grounded in statutory requirements and documented processes, and reinforced through independent review and external enforcement. It bears repeating. The department's role is to identify, document, investigate compliance, act, and refer. Law enforcement role is to establish criminal intent and prosecute, and the court's role is to determine culpability. Each function is distinct by design, and each is essential for accountability. Let me be clear. The department takes allegations of fraud very seriously. Our unwavering commitment is demonstrated through consistent oversight, established processes, and close coordination with law enforcement and federal partners. When concerns are identified and referrals occur, it is evidence that these safeguards are functioning as designed. Ultimately, trust is not built through rhetoric. It is earned through consistent, lawful, and disciplined action. Accountability depends on strict adherence to the law, and that is the standard we apply every day on behalf of the people of Maine. That is the standard we hold ourselves to at the department, and it is a standard that the people of Maine deserve. Thank you for the opportunity to brief the committee on the department's compliance and accountability processes. I will now turn it over to Acting Deputy Commissioner Haber to begin the presentation, starting with the overview of the Division of Audit.
Thank you, Commissioner.
Thank you.
Welcome. Deputy Commissioner.
Good afternoon. I'll echo my thanks. Thank you for the opportunity to present to you today. We'll start with the Division of Audit. The division performs compliance and cost settlement audits on approximately 600,000 provider organizations and/or community agencies that receive over $1.5 billion of state and federal funds through either the Maine Care program or from contracted services. There's two types of audit. One is a social services audit. The other is a Maine Care audit, and that will be the focus of the remainder of the presentation. So we can go to page 9. The Maine Care unit within the Division of Audit performs annual financial audits of cost-settled Maine Care providers. These providers include hospitals, nursing facilities, intermediate care facilities for individuals with intellectual disabilities, residential care facilities, Appendix C, private non-medical institutions, Appendix E. The purpose of these audits is to validate that provider costs are accurate and are in compliance with our regulations, both state and federal. Just to underscore, this is not a programmatic audit. This is not an audit of the service delivery. This is an audit of financial statements. The Division of Audit derives its authority for these under several sources. The first is the Code of Federal Regulations, CMS Programmatic Rules, Code of Maine Rules, and Maine Care Benefits Manual. And the citations are there. Enforcement actions. When cost-settled Maine Care providers are not compliant, the Division of Audit may suspend Maine Care payments until the provider files an acceptable cost report and supporting documentation. They can recall all of the funding until the provider is compliant, or deem costs for unsupported documentation as unallowable for reimbursement during the audit. These actions only occur after multiple communications with the provider, including reminder letters regarding filing deadlines and communications about non-filing and/or unsupported costs. If fraud is suspected, the Division of Audit's process is to refer to the appropriate authority. These are the Program Integrity Unit at the Office of Maine Care Services, the Maine Healthcare Crimes Unit within the Office of the Attorney General, and very rarely the Office of the Inspector General. There are perhaps one or two referrals made per year. And this is not surprising in this category, as these providers are longstanding institutions and they are providing financial statements to us. So there is a built-in level of accountability associated with this category. And that is a very brief overview of the Division of Audit as it relates to Maine Care Audit. We'll be pausing for questions in between each section. So if there are no questions, then we will move on to the next section.
Thank you, Acting Director. Are there any questions? Seeing none.
I'll invite Tom Roth.
Thank you, sir.
Thank you.
Good afternoon and welcome.
Thank you. Thank you, Chairs Hickman and
Appreciate you being
Mastracchio and committee members. Glad to be here. My name's Tom Roth. I'm the Director of the Fraud Investigation and Recovery Unit within the Office for Family Independence within DHHS. Essentially, our unit oversees allegations or looks at allegations of fraud and abuse by recipients, not providers, by recipients. So the individuals that are receiving the benefits through passed down money from the federal government through the state. We have 15 investigators across the state. We have one administrative support person and myself. About half of our investigators have former law enforcement or retired law enforcement, like myself. The other half comes from the program side and has a broad policy background. So it makes for a good team. You see our mission statement. Essentially, we are tasked with going after and prosecuting when possible allegations of fraud. We take it very seriously, and we have a full workload at all times. What is fraud? Fraud is an umbrella term. There's no crime in Maine called fraud. We look at the Maine Care program, the SNAP program, and TANF program. Those are the three primary areas that we are involved in. There are other areas like general assistance, sometimes Social Security supplement funds that we investigate as well. But the SNAP and Maine Care are probably our priority and primary cases that we look at. Fraud or misuse can occur when somebody withholds information upon application or review, provides false information, or uses the benefits in an impermissible way. That could be selling your food stamp card, your EBT card, or giving it to somebody for an inappropriate purpose, using it for something it's not made for. Our criminal charges include theft by deception, unsworn falsification. That's when you make a misstatement on a form and certify, certify to it, or forgery, when someone will bring a document that they've uttered that is not an original document and they're using it to get the benefits. Those are the types of things we look at. We have three basic investigative functions. Initially, we have front-end investigations when someone applies for benefits and the application seems suspect, we take a look at it rather rapidly. And we provide information to the eligibility folks, whether we feel that application is accurate or not. So fraud is looked at immediately right at the front door by both the application people, the eligibility specialists, and by our unit. We also look at intentional program violations, and these are violations of rule that may not rise to the evidentiary level to make a criminal case based upon the burdens of proof that the courts have. We will work with the eligibility staff on that, and we'll handle the intentional program violation as they come up. Those are handled administratively. And then finally, if the evidence rises to a criminal level, we have thresholds in place. We'll refer the case to the Attorney General's office for prosecution. We'll also refer it to some of the district courts if they're a smaller dollar amount case. And on occasion, we'll refer it to federal prosecutors for prosecution by the U.S. Attorney's Office. There are other functions that the fraud unit provides. We serve subpoenas to get the evidence for our cases. Those subpoenas are written by the Attorney General's office for us to get the evidence we need. We serve the IPV hearing notices to get the folks in front of the administrative judges, and we also work with other law enforcement agencies on joint cases. Those joint cases would be anything that involve our purview. If some other crime is committed and one of our rules is violated or our EBT card is misused, something like that, we'll work those cases. Looking at numbers, last year, we received 890 tips and complaints. Most of those were internal from the eligibility staff themselves. That trend is increasing. I provide training to the eligibility folks. Every class that comes in, probably monthly, there's a new class of eligibility specialists coming in. And we try to get them to think in terms of fraud, what to look for, how to report it. So I'm pleased to see those numbers increase. Last year, we also completed 52 intentional program violation investigations. As far as referrals for prosecution, 24 and 25, the numbers are in front of you, the dollar amounts associated with those, and then again, the intentional program violation numbers are there as well. Probably the most recent trend that we're seeing or concerns us is electronic theft of the benefits. In November and January, we had TANF funds stolen from a lot of clients in the state of Maine. That was an electronic theft. The first instance was cards were cloned and they were used at banking establishments to clean out the folks' accounts. The second was a telephone bot was used to obtain client information and passwords and PIN numbers, and cards were manufactured and the accounts were cleaned. We're working with the federal government on that, the U.S. Attorney's Office. Because this is identified organized crime group, the U.S. Attorney's Office will likely prosecute, and we're working closely with them and the U.S. Department of Health and Human Services. We're also going to try to obtain funding to look at this problem a little bit further, what we can do to stop it. The department is looking at putting chips in the cards, much like our credit cards and ATM or ATM cards have. That prevents some of that theft, that cloning and the use of the cards illegally. We make it very easy to report fraud. If you go to the DHHS website, one of the first things that comes up is a portal to report fraud. You can use the online reporting form. We have an email address where fraud can be referred, and that's where the internal complaints come in from. And we also have a fraud hotline that is staffed to answer to listen to any allegations of fraud. Again, I told you we're seeing an increasing number of complaints of fraud from internal sources, which I think is very positive. The other third we get are from the outside, either law enforcement or individuals. I went through that rather quickly, and I'd be happy to listen to any questions you have about the work we do.
Thank you, Director Roth. Are there any questions from the committee about this portion of the presentation? Chair recognizes Representative Strachan.
Thank you, Mr. Chair. Do you have any data about how much was stolen in that cloning of EBT cards from SNAP
The
recipients?
first incident was a little over $30,000. The second incident was just shy of $9,000.
Thank you. Any other questions? Chair recognizes Representative Lee.
I'm trying to figure out who internal sources are without you getting too particular about who internal sources are.
Oh, no, I can speak to that. So when I say internal, those are the folks that are looking at the reviews and the applications for people when they're either applying. So if you apply for benefits, you make application, there's an application filled out, you answer a bunch of questions. The biggest things that we look for are accuracy in income, who's living in your house, that type of thing, what you're doing for work. When something raises suspicion in that, that eligibility person would be an internal reporter. They would report it to us and we would look at it. Again, our training we're trying to make them junior fraud investigators, so to speak, and get them up to speed. And I think it's working well.
Okay. Yeah. So the uptick is a demonstration that the training is effective and that you're.
I'd like to
finding it
think so.
earlier. Okay.
Yeah, I'd like to think so.
Thank you, Representative. Any other questions? Thank you, Director.
Okay, thank you. And next will be the gentleman from the Maine Care Program Integrity.
Yes, Mr. Bill Logan. It's a team. Good afternoon.
Good afternoon. Good afternoon. My name is Bill Logan. I'm the Associate Director of Compliance in the Office of Maine Care Services. One of the duties I have is overseeing our Program Integrity Unit. So to start off, our Program Integrity Unit is responsible for various surveillance and referral activities of Maine's Medicaid program. We currently have 11 full-time positions, a manager, 7 analysts, a surveillance nurse, a planning and research associate, and an office associate. The reason we have a Program Integrity Unit is, well, number one, it's required by law. Federal regulations require that all state Medicaid agencies, as well as territories administering a Medicaid program, have a Program Integrity Unit. And I've also listed here the sections of the Maine Care Benefits Manual that outline Program Integrity's responsibility and some of the major things that we do, which is typically grounds for sanctioning and recouping funds from providers. And I'll get to that in a little more detail a little bit later. So where do Program Integrity's cases come from? A variety of sources. We do receive complaints. Many of those will come in from members of the public. That could be a relative of a member receiving services, somebody working at one of our provider agencies, could be a referral from law enforcement, or a referral from another state agency that had seen something in their course of doing their work. We also generate cases based upon scheduled reviews of either an underlying service or a specific provider type. And that can range from, I want to look at, and I'll pick a random type of provider, dentists. So I'll pick a random sampling of dentists to look at. Or we may want to look at a specific service because we're seeing perhaps high utilization of a specific code or something. So they can be varying different levels of complexity depending upon that. Those typically can be informed by data analytics. We are running reports, queries to see if there's something unusual in claims data that warrants perhaps looking into. Program Integrity also does a random mailing on a monthly basis of explanation of medical benefits letters to recipients. These are telling them, hey, similar to what we all get from our insurance company that says, hey, we see you had a service, here's how much we paid, here's how much you're responsible for. It's just a mechanism we utilize as a checks. And we do get sometimes a call back where someone says, hey, I don't think I got that service. And that may warrant further investigation as to whether they're just messing up a date or whether their service actually wasn't provided. And we also utilize more recently electronic visit verification data. That's typically that providers are required to check in utilizing phones or other types of electronic devices when they're starting a program, a service. Typically, these are in the home or out in the community, and then when they end. That gives us an electronic record of how that is, that we can certainly true up against the claims that the provider subsequently submits. What we do generally is conduct post-payment reviews of Maine Care providers. I'll walk through that a little bit, but those are often desk reviews of the provider's documentation about that support the claims that they billed Maine Care for. We also do various activities to detect fraud, waste, and abuse in the program. You've heard before that we do referrals to the Healthcare Crimes Unit for credible allegations of fraud, but we will also refer other matters to them if we suspect that something might rise to the level of criminal activity. We also collaborate with a CMS contractor. This is it's known as a Unified Program Integrity Contractor. We call them the UPIC. Essentially, they will conduct reviews of Maine care providers for us, and we work in conjunction with them to ensure that those meet the requirements of our reviews and that they align with our policies and interpretation of those. We impose payment suspensions when warranted. There's been some discussion about that. That's done typically when there's a credible allegation of fraud. I'll get that in a little more detail a little bit further on. We also exclude individuals from the Maine Care program. We've already talked about the EOMB letters, and we will also make referrals to other agencies that might have oversight, either a licensing board, potentially to adult or child protective services if we're seeing something in the records or in our investigation that warrants that. I've put up here definitions for fraud, waste, and abuse. These are taken from CMS, the Centers for Medicare and Medicaid Services. Fraud is essentially wrongful or criminal deception intended to result in financial or personal gain. We have some examples of that, what we enumerate in the Maine Care Benefits Manual, but there's no one single definition for that. Waste and abuse is the primary things that we are seeing in our cases. That's either thoughtless or careless expenditures or mismanagement or improper billing or improper usage or utilization. So just as a walkthrough of how a standard program integrity provider review works is generally we start off with program integrity requesting a number of records from the provider. Providers will typically get those to us within preset time frame, 15, 30 days, depending upon the number of records we're requesting. Then the staffer will take those, review those records against the requirements that are set forth in the Maine Care Benefits Manual. At the conclusion of that review, it determines that the records are all up to snuff, that there's nothing to see there. The provider will receive what we call an NSF letter, a no significant findings, and we'll close that case out. If we do find violations, they will receive what we call a notice of violation, an NOV, explaining which rules they violated, and a detailed spreadsheet will be attached to that with the claims information so that they could identify the specific records that we found to be wanting in some fashion. And in some cases, we might issue a draft notice of violation to provider as a courtesy if we think there's perhaps a misunderstood what we're asking for the records. If we see a bunch of things missing, just to give them an opportunity to get those back into us before something goes out on an official basis. The things program integrity is generally looking for, lack of documentation or inadequate documentation. So either a missing progress note, office visit note, or it wasn't done correctly. Perhaps it requires a signature that's not there. Perhaps some key information is missing from that. We look for if they are billing for services, but the services were not actually provided. Generally speaking, if you don't have an office note for a date that you billed, you didn't document it, I'm going to assume it didn't happen. Impossible days. Did somebody bill for more than 24 hours in a day? Typically impossible unless more than one person is doing work for an individual on that day. We verify staff qualifications, various different sections of our rules. We'll set out different qualifications for the people to deliver the service. And so we're verifying whether the provider has people who are qualified to deliver the services for our members. We look at coding issues, including upcoding, overbilling of units. If the medical records indicate either a lack of service or a lack of a specific diagnosis that the person should be receiving that service. And of course, we're always on the outlook for any patterns or outliers in our data.
Sir, what is upcoding?
Example of upcoding would be perhaps that you may have a code that's a 15-minute code, another code that's a 30, and you bill for the 30-minute code instead of the 50. Basically, it's any type of utilizing a code that'll get you higher reimbursement when a lower one is available and should have been billed. So if we do find bad things or violations, what do? We do have sanctions. Primary sanction for providers is monetary recoupment. We take back 100% of what was paid on the claim if the provider's records don't demonstrate that it was a medically necessary Maine care covered service. We have a provision more recent about signatures. If the member or guardian hasn't signed off on the service, and that's required by the rule, we take a 25% penalty for that claim. And then for other types of documentation errors, we can penalize up to 20% of a claim, as long as and those are instances where the provider has information that shows that a service was provided, just the documentation about that is lacking in some manner.
Chair recognizes Representative Lee with a question about that.
Sure.
The scheme I'm calling it a scheme, that sounds pernicious, and I don't mean it that way. The process for determining between 100% violations versus 25 and 20% violations, is that from the benefits manual's discussion of medical necessity? There's a determination that 25 and 20, the service was necessary. It's just you had a paperwork error.
Sure. Yeah. The 100% is when we look at it and it's either not medically necessary because for whatever reason. A terrible example is if I got a bill from a hospital that showed a janitor did a surgery. You can't have that, right? So unqualified staff, that'll be 100% recoupment. If the records show that the service has to be signed off on a doctor and I have a progress note, but that doesn't have a doctor's signature on it, then that's going to be in the 0 to 20% range. And the way our rules are structured, we start off at 20 and a provider can request an informal review and request that it be lower based upon whatever argument they want to give. And then we would take that into consideration and make an adjustment if we felt it was warranted. Beyond that, we have the ability to do a bunch of other sanctions. Can request the provider develop and submit to us a corrective action plan on how they're going to avoid these penalties, not penalties, but these violations from occurring. We can suspend referrals, meaning we're not going to send any more of our members your way. We can place limitations on providers saying you can't enroll any more service locations for a period of time. You can't take on any other members. And of course, we always retain the ability to terminate a provider or exclude them from the Medicaid program.
Chair recognizes Representative Strachan.
Thank you, Mr. Chair. And I just want to ask this as we're going along. When you say provider, a lot of people might think that that's just the doctor sitting in his office. These are often the provider is a group, pharma, for example, or, so can you just elaborate on that a little bit, what you mean by providers?
Sure. Luckily, I oversee provider enrollment as well. So when I say provider, when we're looking at what we call the pay-to provider, the provider that receives the money. Now, that could be an individual, but it also could be a physician office that has 17 doctors who are also providers. They're enrolled individually as well under that. But yes, it could be a mental health agency, a dental agency, a hospital.
Representative Lee.
And in the context of, say, a mental health agency, oftentimes you have one institution, but within that there are several independent contractors often. Is that the case that you see?
I think, with any type of a provider agency, let's take a behavioral health clinic or a mental health clinic, there's the entity, and then they may have their employees underneath them that may or may not be required to be enrolled as what we refer to as rendering providers, the provider who's delivering the service. But it's ultimately the responsibility of the provider who I'm giving the money to and who's submitting the claim to ensure that all their people are doing the right thing. Is that helpful?
Yeah, it is. I have some passing awareness of some institutions that operate with several independent contractors, and sometimes the training of those individuals is difficult, particularly on these sorts of paperwork.
The employee-employee relationship is really irrelevant for my purposes, because whether they're an employee or independent contractor, the provider is responsible for the bill and the records.
Yes. You may proceed.
Thanks. So I'm going to turn to credible allegations of fraud. If program integrity receives an allegation or a complaint of fraud, we are required under federal law to conduct a preliminary investigation. Where do these come in from? It could be a fraud hotline complaint, claims data mining, patterns that we see when we look at the provider audit, civil false claims, or law enforcement investigations. Oftentimes, I mean, and they can come from all these different things. I mean, personally, I've had someone called me up directly on my line with an allegation of fraud. Generally, that's only one. They would typically more often come in through a call to our hotline or through what we're identifying in our case. We're required to do a review of that to determine whether that's valid. And if we find that it is valid, which is that we're able to do that based upon one or more indicia of reliability, then we're required to suspend payments to that provider unless we are able to determine and document that good cause not to suspend payments exists. So we have a procedure in the Maine Care Benefits Manual around that. And good cause, there are a few different examples. The primary one I think that gets cited, I would say, is that law enforcement asks us not to because it would compromise their ability to conduct an investigation into the provider.
Can you
Okay. We can also decline to do the suspension if we think other remedies exist to protect Medicaid funds. If we determine, based upon evidence from the provider, that, okay, perhaps we don't think there is fraud. If we determine that member access is going to be jeopardized, for example, the only doctor in a 100-mile radius, that could significantly impact. If law enforcement has taken the case, but then declines to certify that they are continuing to investigate it, which they do on a quarterly basis to us, or if we make a determination and document that it's not in the best interest of the Medicaid program to impose a payment suspension. These are temporary suspensions. That doesn't mean that they're necessarily short. They are continued until the investigation and any associated law enforcement proceedings are completed. So that could take a significant amount of time in the real world, especially if it's a case that ends up going to court. And that's why on a quarterly basis, program integrity requests certification from the Healthcare Crimes Unit that the case. And sometimes you'll hear the Healthcare Crimes Unit referred to as the Medicaid Fraud Control Unit, or MFUCU. MFUCU is the federal term. Like all good governments, we have to use a different term. So they're the Healthcare Crimes Unit. So what happens after a provider receives a notice of violation? They have 60 days to request an informal review. This is their opportunity to provide us with a written statement of all areas where they disagree or all issues they have with our findings, and to provide us with any additional materials that they want us to review. Any issues that they don't raise at that point get waived. That will be assigned to a different program integrity staffer to conduct a review. And then they will issue what's known as a final informal review decision at the conclusion of their review, which could overturn the initial findings, uphold all the initial findings, receipt of additional documentation that was not initially provided.
Representative Mastracchio has a question.
I guess I just have a question about what happens if this is we're talking about a main care provider. And at some point in the process where you're saying that there has been, or there's an allegation of fraud, doesn't ever get to the point where it goes to the Attorney General's office and the person then withdraws from the main care program. You've stopped payment, but is there ever a point where you don't recoup the money? Do you understand what I'm asking? You know,
I
it's
think I do.
because you could withdraw from the program and just say, well, that's all right. I'm going to close my business and I'm not going to do any main care. So I'm just asking that at what point does it then not go to the Attorney General's office, or do you just lose that money?
So,
Because I'm just looking at this thinking, well, okay, if I was, at some point, you realize the review where it's going to go and you might just cut your losses.
yeah, I'd like to separate out the fraud cases, because once those go to the Attorney General's office, they're going to run with those.
Regardless.
Now, if we're talking about just a standard, I've issued a provider a notice of violation that says they owe us $100,000, and they just say, well, I'm just shutting my business. I am, depending upon how they.
So if I was a provider and you say that I owed you $100,000 and I decide that I don't want to pay you the $100,000 because I don't have it, and I go, whoa, I'm just closing my business, we do nothing, and they get the $100,000 to keep it?